rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is State Farm versus LaRocca, number 2025-0674. Whenever you're ready.
Thank you. Mr. Chief Justice, and may it please the Court. The legislature enacted the Health Care Clinic Act in response to massive fraud and kickback schemes. That statute presents clinics with a choice: submit to a licensing regime aimed at compliance, or, as is relevant here, satisfy an exemption that requires one of the clinic's owners to be a licensed practitioner who is supervising the business activities and is legally responsible for the entity's compliance with all federal and state laws. Based on the statute's text, structure, and purpose, an owner who is legally responsible has a duty for the clinic's compliance with the law.
Do you want to start with addressing the question that we asked in the focus order about whether this legally responsible language is applicable when it's wholly owned by licensed physicians?
Yes, happy to do so, Your Honor. I think a number of textual clues indicate that the requirement applies to both the clinic wholly owned by licensed practitioners and co-owned by lay family members. I'll start with the series qualifier canon. That exemption applies where a statute uses a list of nouns and verbs followed by a modifying clause, and that's consistent with the text of the statute here. And so, as the Supreme Court said on Facebook, and as this court recognized in DeSantis versus Dream Defenders, under conventional rules of grammar, and there's a straightforward parallel construction that involves all nouns in a series, a modifier at the end of the list normally applies to the entire series. In addition, the purpose of the Clinic Act is consistent with reading it as applying to both. As one federal district court recognized, and this is State Farm versus Performance Orthopedics, it's unpublished, but it's at 2018 Westlaw 2186-496. If an unlicensed clinic could avoid regulatory oversight simply because its owners were wholly owned and it was irrespective of satisfying the supervision and responsibility requirements, that would be inconsistent with a purpose. And the court said that it would lead to an absurd result, which is that a wholly owned clinic could have a situation where they delegate all responsibility to a layperson and they would avoid any regulatory oversight in that situation. And finally, I'll note that the Agency for Healthcare Administration has taken the same view that the requirement applies to both. On the form claiming the exemption, regardless of the ownership structure, it says that the supervising licensed healthcare practitioner owner has to sign the form. And that's reprinted in the record. That's in our appendix, volume 1, and it's district court docket number 256-4, if you want to see an example of one of those forms. So for all those reasons, I think the requirement applies to both. Happy to answer any further questions on that, or I can proceed to the affirmative argument that I have.
You can move forward with your argument.
Counsel, for this court to have jurisdiction to answer the certified question, it has to be determinative of the cause. This was a jury trial. How did the issue that you're raising, the legal question that's been put to us, how is that determinative of whether there was error in the judgment entered on the verdict?
Yes, so Your Honor, in the federal system, number one, this would be a federal procedural issue, so the 11th Circuit necessarily decided that this was a dispositive question of state law. But just to go into the analysis of the 11th Circuit, in the federal system...
Well, don't we get to decide what our jurisdiction is? I mean, it's the Florida Constitution. We get to say whether this is actually determinative, don't we?
Agree, and I think that then that would look to federal procedural issues. And so what the Supreme Court has said is that a pure issue of law, it can be preserved on a motion for summary judgment, which is what State Farm did here. So we had...
Right, but how does that legal question, what's on appeal in the 11th Circuit is the judgment, right?
That's correct.
And your client lost at trial, right?
That's correct.
So how does a denial of a partial summary judgment motion constitute error that's prejudicial that contributed to, I guess, an unfair trial or something like that?
Because the posture here was State Farm proceeded on either of two theories of liability. One was medical necessity theory, and that was under the no-fault statute's non-compensability provision. The second was the Clinic Act theory, which is before this court. That proceeds on the non-compensability provision of the Clinic Act. And so the denial of summary judgment and the district court's resolution of that question as a matter of law, precluding State Farm from presenting it from the jury, carries forward. And once we appealed the final judgment, we necessarily appeal all interlocutory orders embraced by that judgment.
Yeah, but how were you precluded? Did you attempt to propose a jury instruction or get it on the verdict form during pre-conference or before the pre-trial conference?
During pre-trial conference, we asked for reconsideration and asked the judge to allow us to present this theory to her. She said that we were not allowed to do so as a matter of law.
Well, so, I mean, what does that mean to present a theory? I mean, you're going to trial. You presented evidence. I mean, it sounded like at the oral argument, the 11th Circuit, that you did present evidence, or it was suggested that you had presented evidence on that theory or could have been gleaned from that theory. The theory is going to be manifested in the jury instructions and the verdict form. What did you do, or what did your client do to get that, or at least propose that they be included in the verdict form and the jury instructions?
So both at the pretrial conference and on a motion for reconsideration, we argued that we should be entitled to instructions on this theory, and we were denied. And so I think for those reasons, the 11th Circuit found that this was a dispositive state law issue, and I hope that satisfies this court as well. I think it was preserved both under the 11th Circuit precedent and under Supreme Court precedent, Supreme Court of the United States. As far as the substantive issue here, I think that the statute has to be read to impose an affirmative duty. That is supported by the plain text of the statute, by the purpose, and by what other both courts and the Agency for Healthcare Administration has determined to be the proper reading of the statute. So
it seems like the way this is written, though, it's written in terms of two things: is supervising, which kind of implies some sort of ongoing activity that they're doing. But then the second thing is it says is legally responsible for ... It doesn't say is ensuring compliance. And so it's almost like the is legally responsible is more of like a kind of a status that you would think that there would have to be some kind of outside source of law that would make one legally responsible, and that, you know, once that is triggered, then that sort of allows the exemption to go forward. Why isn't, given sort of the different way that those two things are phrased, why isn't that the right way to look at that?
So I think actually the fact that both are phrased using the active verb is suggests that they are an ongoing and active state that someone has to obtain and maintain. And that's the position that the Agency for Healthcare Administration has taken, as we cited in our brief. So the verb is typically describes the act of, you know, an act, it's to be. And so here is legally responsible for the entity's compliance with all federal and state laws.
But I mean, you agree, though, that there's a difference between saying that someone is supervising versus is legally responsible. I mean, don't you think that the parallel thing would have been something like, you know, is ensuring that the entity complies with all federal and state? I mean, it seems like that would be the parallel thing.
I disagree. I think that the legislature would have had reasons to avoid potentially using the word ensuring, because it would produce the potential for perfect compliance with all federal and state laws. By phrasing it in terms of an active verb, is legally responsible for the entity's compliance with the law, the legislature meant to convey an active duty. And there are other textual clues that you can take from that. Typically, when responsible is paired with the word for, it conveys being in charge of something or being appointed to look after something.
What, in your view of the statute, what work is the word legally doing?
So the word legally, I think, just conveys that they have to have legal compliance with the law. I will say that the legislature is somewhat inconsistent in its use of legally. There are other exemptions that require the same responsibility and supervision, and the legislature dropped the word legally from responsible beforehand. I don't attribute any significance to that beyond the fact that different legislatures or different sessions of the legislature amended the statute. I'm not suggesting that the word does no work, but it clearly, the legislature meant to convey a similar duty in different provisions and dropped it on occasion. As far as what I think this court should focus on is legally responsible for the entity's compliance. Again, responsible typically means being in charge of something or being appointed to look after something.
Can I push on that? Like,
yeah.
You've said that now a couple times, and I don't know what support you have for that assertion. If I'm responsible for the charges of something, it means I'm going to pay for them. It doesn't mean I'm legally responsible for their direction or control. If I say I'm responsible for my child's tuition, you've now asserted as a matter of like usage that when I'm responsible for something, I have some affirmative like piloting to do. What evidence do you have for that statement?
And it's an excellent question. It's based on the pairing with legally responsible for the entity's compliance. And I think compliance is the key word there. When the legislature uses the word responsible to convey some kind of liability, it typically speaks of pairing it with a debt or transgression. So in the other side's brief, they cite numerous examples, and all of those fit a pattern where the legislature is talking about responsibility for a payment or for a debt or for a violation or for a failure to comply with the law. But the legislature didn't speak of a violation or a failure to comply with the law. It spoke of responsibility for compliance with the law. And so those positive states to us signals that the legislature meant to convey an affirmative duty here.
The effect of your interpretation is basically that in the definitions section, there's created a conditional license so an entity can start out licensed, meeting the definition. Through their actions, they can become unlicensed, and and I guess your standard for that would be substantial compliance with the laws, right?
I think that the objective duty that we're asking for could be measured in terms of substantial compliance. At the end of the day,
well, we would typically look to the statute to tell us that, correct? If somebody's going to lose their license for failure to comply with the laws, the statute would tell us under what circumstances they would lose the license.
Yes, and what I'm saying is that in looking at the statute, you would focus on whether or not the owner was legally responsible for the entity's compliance. So your focus would be on the owner's actions.
So you're asking us to do a lot, and then the penalty or I guess the consequence of losing the license would then be that these claims are non-compensable and there's no obligation to pay them. Correct?
That is correct.
And we get all of this from the language is legally responsible.
Is legally responsible for the entity's compliance, which I think is the key.
So my concern with the argument is that you've asked us to make a lot of assumptions about what the statute does operationally, when structurally all we're looking at is, this phrase in a definition section. That seems to be an interpretive leap that we don't typically take. So what overall structurally in the operation of the statute do you think supports this determination that created in the definition section is a conditional license that has a penalty of non-compensability?
Yeah, so I think you can go beyond just the particular provision. If you look at the parallel requirements for a licensed clinic has to have a clinical director, and that clinical director has to accept legal responsibility for a set of enumerated tasks. And what the 11th Circuit held in the Viscay case was that legal responsibility equates to a duty to carry out those functions on behalf of the clinic. So that's one textual clue. Another is how legally responsible or responsible for compliance has been construed in other settings. For example, we cite the example of a borrowed employee statute. So the legislature has allowed judicial circuits to borrow county employees. Those judicial circuits have to be responsible for compliance with all state and federal employment laws, and then they have to separately indemnify the county for violations of those laws. So if the legislature equated responsible for compliance with liability, they wouldn't have needed to include that separate section of the provision. So I think that that also demonstrates, we cite the example of a child welfare statute where someone is legally responsible for the child's welfare, and the Attorney General gave an opinion that that meant a duty to carry out care for that child. So I think all of these clues demonstrate that when the legislature pairs responsibility for some affirmative obligation, not for a debt or transgression, they mean to impose a some kind of duty of care.
It seems like a really weird kind of regulatory system, though, that you're describing, because there's so much judgment, it sounds like, involved in sort of deciding whether someone is satisfying this duty that you're describing. It seems strange to have, a government agency that's supposed to be looking at, who's licensed and who's not and what they're doing. And then on your theory, you're going to have, all these disputes arising potentially about paying claims, and it's going to be kind of in the courts to decide, initiated obviously by someone who doesn't want to pay and is alleging that the duty hasn't been satisfied. And the courts are going to be having to make these very kind of fine-tuned judgments that you really associate, I think, more with the kind of discretion that you would give a regulator. How does that make sense?
So a few things, and I want to be mindful that I'm using some of my rebuttal time. So number one, and I just, because this will address your question, but also Justice Sasso's point, the legislature enacted this scheme because existing remedies had proven inadequate. And so it is somewhat strong medicine, but it's strong medicine on purpose. If a clinic is providing medically necessary care, but it doesn't have the license and doesn't have the exemption, the legislature said those claims are non-compensable. As far as administrability, courts have been doing this all the time. The way the no-fault scheme is set up, an insurer has 30 days to pay, and if they don't pay within 30 days, the claim is overdue. And there's statutory interest on those claims, and one of two things can happen. The insurer, like State Farm did, can bring a declaratory judgment action. It's determined, and if State Farm's wrong, we'll owe interest on the claims. And if it's substantiated, then the owner is not provided with recompense on the claim. And then the final thing I just want to point out is that you also have to consider the flip side interpretation of all of this, which is that this would be a strange way to impose vicarious liability on the owner of a clinic. Doing it through
would it be vicarious liability, or not just be recognition of the typical penalties that are associated with somebody that holds a medical license? I mean, essentially, if you hold a medical license, your license is on the line, and there's all sorts of regulation and the context of licensure that might motivate somebody who's legally responsible for legal violations in a way that a layperson who's running a healthcare clinic as a director, there might need to be additional protections for that. So why would that not be a logical determination by the legislature?
Because there are already provisions that provide that if a licensed practitioner isn't abiding by the Clinic Act, they can face discipline. So this provision has to do additional work. I think the other side would concede that. The way they're saying this provision does additional work is by imposing vicarious liability, which is odd through a definitional section, presents its own form of observed results, and also disregards the presumption that the legislature doesn't act in derogation of the common law. If there are no further questions.
Can I ask you one question? Can we just close the loop on the question that Justice Sasso started with whether the qualifier applies when the clinics are wholly owned? As far as the record here goes, are all these entities wholly owned?
They are, Your Honor.
So if it turns out that the interpretation is that the language we've been talking about only applies in the context of mixed ownership, then at least as applied to this case, the issue would be off the table.
That's correct, Your Honor. And if the court has further questions on that, we're happy to submit supplemental briefing after the fact. But thank you.
And just following up on that, does that mean that then it's not determinative of the cause and we would not have jurisdiction to answer the question?
I don't think in that particular scenario it would be determinative of, or would be not determinative of the cause, because that would be a state law issue, right? And so if it's a state law issue, it would still be deposited.
Well, but the question that's been put to us is, what is the meaning of this, of legally responsible? But if it doesn't matter for this case, then it's not determinative of the cause. Why would we have to answer the question?
As I understand the 11th Circuit certification order, they allowed this court to modify any other issue of state law. That
yeah, but do they get to do that?
Well,
I don't want to tell the 11th Circuit.
We would say that it's not, that it doesn't apply to this. We would say it doesn't apply, therefore we're not going to define it, but that doesn't mean that we couldn't say it doesn't apply. I mean, the answer there, we would just rephrase the question to say, does this apply to this thing? You can have an extra minute for rebuttal.
Thank you, Your Honor.
Mr. Chief Justice, and may it please the court, my name is Patrick Causey and I represent the appellees. The phrase legally responsible means answerable, accountable, and liable. That is the primary definition of the phrase and is consistent with how that phrase has been interpreted by this court, the Florida legislature, and in the past, State Farm itself. And it is the only definition that this court can adopt that would avoid a judicial rewriting of the wholly owned exemption while furthering the purpose of the Healthcare Clinic Act by protecting patients and giving owners a powerful incentive to run their clinics in an appropriate manner. While appellees have maintained the same definition throughout this proceeding, State Farm has changed its plain language interpretation of the phrase legally responsible 4 times in the last 3 years. Each new interpretation it has advanced, however, all suffers from the same fundamental defect.
Can you start out with the question that we ended with, whether you agree that all of these clinics are wholly owned and that there's no mixed ownership issues presented?
Justice Sasso, yes, these clinics are wholly owned. That issue is not disputed. Dr. LaRocca owns 10 of the clinics 100%, and for 2 of the other clinics, he owns them with another healthcare provider, Dr. Michael Major and Dr. Jason Hunt. So that question is not an issue in this case. Mm-hmm. And turning to the first issue that I know you asked us to address, which is whether this idea of legal responsibility and supervision applies in this context, I think the answer is pretty clearly no. I think the wholly owned exemption has 2 clauses within it. One is it applies to a wholly owned clinic that's wholly owned by a licensed healthcare practitioner. And the second clause has to do with a clinic that is jointly owned by a licensed healthcare practitioner and a layperson, so long as the licensed healthcare practitioner is the one that is supervising the business activities of the clinic and is legally responsible for compliance with all state and federal laws. Importantly, there is no punctuation in that second clause, like a comma or a semicolon, that would suggest that that supervision and legal responsibility requirement applies to the entire paragraph. And I would actually point the court to
I'm sorry, have you argued this? Have you argued this in the federal chain?
We did not raise this argument in the federal chain, Chief Justice, but we are responding to the order that the court raised last week.
And if you had, we probably wouldn't be here. If you had, and if that's right, is it true that we wouldn't be here?
Well, I think State Farm likely would have still appealed that decision if the court rendered that ruling.
That's why I said if you were right. And if
I'm sorry, yes. If we were right, then, well, I think we still would be here, potentially, if they certified the question.
Maybe we would have been asked a different question.
Possibly, yes. We would have been asked this particular question by the 11th Circuit. But I want to point the court to the book, Reading Law, by Justice Scalia and Brian Gardner. And in particular, on page 163 of that book, they use an example of a contract clause that I think is directly on point. That contract clause had to deal with a Canadian company. And the clause said specifically that the contract shall last for a period of 5 years, comma, and a subsequent 5-year period, comma, and that second comma is important, unless it is terminated by either party by giving 1-year written notice. And what Mr. Gardner and Justice Scalia noted is the presence of the second comma in that contract made clear that the ability to terminate applied to both the initial term and the subsequent term. Well, in the wholly owned exemption, we don't have that second comma. We don't have any punctuation that suggests the supervision and the legal responsibility requirement would apply to an entity that is wholly owned. So I think the easiest answer to this question from the 11th Circuit is to rule that the supervision and legal responsibility requirements does not apply to a clinic that is wholly owned.
Go ahead.
I'm a little confused. Maybe you can help. So I listened to the oral argument in the 11th Circuit, and there was some discussion about abandonment.
Yes.
And it was actually in the trial court's order as well, mentioning in the denial of the motion for judgment as a matter of law at the close of State Farm's case, this idea that they abandoned the theory. So actually there's no need for there to be a judgment on that theory. I don't know how that would work, but was it because your opposing counsel has said that, no, we did propose a jury instruction, did ask for it to be on the verdict form or something like that. Which is it? Did they abandon it, or did they actually press the issue and try to get it in the instructions in verdict form?
They did ask for an instruction in the jury verdict form. The point that we were making at the 11th Circuit and that we've maintained from the beginning is that, and Judge Bucklew made this position as well, they still had a claim that they could bring, which would be a more traditional kickback or patient brokering claim where they would try to prove, okay, here's the body of patients that were referred to the clinics based on a kickback, and those claims should not be compensable. State Farm did not want to bring that claim to trial for reasons known only to them. It was actually the day before trial that they decided to affirmatively abandon that claim because they only wanted to proceed on this silver bullet theory of liability, that if they could show some violation of a state or federal law, then the exemption is lost and all of the claims are non-compensable. So to the extent that we're dealing with the abandonment issue, it's simply to point out that they had the ability to move forward on the traditional theory of liability, and they voluntarily chose not to.
In the instruction that was asked to be included and I guess denied, it used the term legally responsible, or asked the jury to make a factual determination of whether they were legally responsible?
It asked the jury to make a decision, a factual determination as to whether they were ensuring compliance with all state and federal laws. And Judge Buckley ruled as a matter of law that that was against the plain language of the statute, so she was not going to allow that claim to go forward.
Because of her interpretation of legally responsible?
Precisely, Your Honor.
Okay.
So do you think on the, sorry.
Go ahead.
Okay. On the legal issue raised here, that under Dupree, that this is a purely legal issue, that even though it was denied on summary judgment could be raised
Yes.
on appeal in the 11th Circuit? You agree with that?
Yes, Justice
Okay.
Essa.
So I understand your argument about the punctuation, which I think is a strong argument, but can you substantively, could you explain to us, kind of lay people, generalists here, is having the wholly owned thing, not needing the supervision and the legally responsible thing, would that kind of leave the two things kind of substantively in the same situation?
I think it would.
In other words, as a matter of law, if it's wholly owned by the licensed person, are those things kind of imputed to them so that it's basically they're being the two situations are being regulated in the same way?
Yes, and I think that's a great question. I think at the end of the day, if you are wholly owned, you still have a duty or an obligation to make sure that your clinics are running in an appropriate manner. We've never argued otherwise. And I think if you look to 400.9935 subsection 5 of the Healthcare Clinic Act, it says a licensed healthcare practitioner who violates this act is subject to discipline, which I believe Justice Sasso suggested might be the most appropriate interpretation of this legal responsibility clause. And so if you are wholly owned, and you're allowing your clinic to go out there and violate laws left and right, and you're not actually making sure you're doing things in an appropriate manner, you could lose your license. And then if you lost your license, you're not going to qualify for the exemption to begin with, and you're not going to be an exempt entity that can operate in the state of Florida and being reimbursed for the claims. Now, I want to turn my attention for a moment to the actual definition of the phrase legally responsible. We've cited to a number of authorities that support our interpretation that it means accountable and answerable. It's the primary definition that's advanced by Black's Law Dictionary. But I want to focus in on one case in particular that we cited, which is the American Mutual Family Insurance case versus Williams. It's out of the 7th Circuit. It was cited by the 11th Circuit when it certified the question to this court. And the reason I want to focus in on that case is because State Farm has argued every example that we have given only refers to some form of payment obligation of payment or expenses or a liability. The Williams case does not do that. The Williams case involved a guest staying in a home that took a dog for a walk. That dog was owned by the homeowner. The dog got excited when it saw another dog. It lunged at the dog, causing the guest to fall and hurt himself. He sued the homeowner and asked for coverage of his injuries, and the insurance carrier denied coverage on the basis of an intra-insured exclusion and said, we're not going to cover a lawsuit between two insureds. Well, the definition of insured in that policy said that the person who is legally responsible for the pet of a homeowner. That was it. The phrase wasn't defined. The insurance company argued that should mean they had a duty. They said he had a duty to take care of that dog when he was walking him. The court rejected that. It referred to the primary definition of the phrase as being answerable, accountable, or liable, and it found the person walking the dog, the guest, wasn't liable for the dog just because he took it for a walk, and so they rejected that court's interpretation and found that insurance coverage existed. So that's an example that we have given in our brief where the phrase legal responsibility is meant answerable or accountable, and it contains no reference to a payment obligation or having to pay some form of fees. At a practical level, though, I'm not surprised that most of our examples have reference to payment of fees or obligations. It's the primary definition of the word. Of course, that's what it's going to be used in most of the time within the context of that phrase itself.
So in practical terms, though, where does your understanding of the statute leave them? So let's assume that the clinic the owners haven't been, they haven't been supervising, they haven't been doing anything to ensure compliance, and let's say there's some disciplinary action brought and the license is revoked. Where does that leave them as far as the application of the part of the law that says that claims aren't compensable where the entity's been in violation of the law or is in violation of the law? I mean, how does it work?
So two things on that point, Chief Justice. Number one, State Farm or Geico or any insurance company can still bring a claim against the clinic for fraud or medically unnecessary services, as they did in this case. They had a 3.5-week jury trial, and the jury ruled against them and found that the clinic wasn't doing anything unlawful. So they can still bring that claim, and they still have a remedy. To answer your other question about the interplay between the definition section, and then I think it's 400.9935 subsection 3, which State Farm relies upon as the hook for arguing our claims are uncompensable. If you look at that statute, that actually says that a clinic that is required to be licensed but is not so licensed, those claims are unlawful and non-compensable. And in her order denying the motion for reconsideration, Judge Bucklew specifically pointed out that, okay, that scenario speaks to where a clinic is not wholly owned at all, and they lie, they're owned by a layperson. Well, in that scenario, they are required to be licensed, and they're not so licensed, so those claims are non-compensable. But if you are wholly owned, you qualify for the exemption, and therefore, by definition, you are not a clinic that is required to be licensed, but is not so licensed. And she explains this in her order denying the motion for reconsideration about how that penalty provision in subsection 3 wouldn't apply to a scenario like this. And I want to point out one other interesting note about the definition section, which Justice Sasso was talking about earlier, saying, there's really no indication that a violation of this wholly owned exemption could potentially lead to that exemption being revoked. Well, in the definition section, there's actually only one subsection that says you could lose your exemption if you violate it, and it's subsection N, and it deals with a healthcare entity that has 50 or more licensed healthcare practitioners, and they're billing all under one employment identification number. And it says that they, in order to be exempt, they are not allowed to accept PIP payments. And it says in the very last sentence of that subsection, if the agency finds that you are accepting PIP payments, it can deny your application or revoke your exemption. That is the only exemption in the entire definition section that uses that language. That language is notably absent from the wholly owned exemption subsection G. And I think that is as clear of legislative intent as you can find, that the legislature did not intend, if an owner of a wholly owned clinic is alleged to have violated a state or federal law, that that means that the exemption is revoked after the fact. Now, I want to spend my last 5 minutes addressing what we see are the fundamental problems with State Farm's interpretation of the statute. And there's really 4 problems with it. Number 1, they're still asking you to add the word insure to the statute when you interpret the statute. And Chief Justice, you mentioned this, that you would think that they would add the word, the legislature would have put the word insure next to legal responsibility. Well, if you look at the medical director statute, 400.9935, that's exactly what the legislature did. It told the medical director that it had to ensure 6 of the 9 obligations that were imposed on the medical director. It used those specific languages. Ensure that you're complying with the record-keeping statute. Ensure that your doctors have the appropriate licenses and certifications. It used that language, and it did not use it in the wholly owned exemption, which is, I think, again, is a clear indication of the legislature that it did not impose the obligation to insure.
And the way you read the statute, though, even if this said that they had to be actively insuring and they weren't doing it, you would still say that they wouldn't lose their exemption? Is that based on what the last argument that you were making?
Correct. I think
so would it really even matter?
It would matter because they could still be subject to discipline under...
Right, but I'm saying for the purposes of this dispute.
For the purpose of this dispute, it would end the claim. This court would basically say it doesn't impose an obligation to ensure compliance, and then that would answer that question, and then there would be no liability that would attach to Dr. LaRocca and his clinics.
I guess my point is, even if we said that there is some sort of obligation to ensure compliance, it sounds like you're saying that that wouldn't have the consequence of taking away their exemption. If they weren't doing it.
I think that if the court were to determine that even if you were to show that you aren't ensuring compliance and that's what the statute requires, that it doesn't then lead to a private party being able to revoke the exemption, then that's certainly an interpretation this court could adopt. We don't agree with that interpretation because we don't think the word insure is in the statute for a reason. The other second way that they're rewriting the statute is they're asking you to remove the word all from the phrase all state and federal laws. Because if you look at State Farm's brief, they say, well, a judge or a jury certainly can decide if the scope or severity of a violation is sufficient to warrant revocation of an exemption. And they talk about, if it's a particular law or if the violations are particularly severe. The wholly owned exemption contains no such discretion. It doesn't say some laws. It doesn't say laws that are violated at sufficient severity. It says all of them. So they're asking you to, again, rewrite the statute by removing the word all from it, and we don't think that's appropriate. And then the last 2 points I've already kind of addressed. So
if, let's say we agreed with State Farm's position or State Farm's reading, and we answer that question, send it back to the 11th Circuit, what does the 11th Circuit do with that? Like, what then is the prejudicial error that flows from the answer to the question, and what is the relief that they would get?
Well, I think that would be up to the 11th Circuit. My assumption is that the 11th Circuit would likely remand the issue back to the trial court to have the trial court then decide if the claim can move forward based on this interpretation and whether they can present the claim either at the summary judgment level or we would have another trial.
Well, okay, so they would, the relief would be that the judgment was an error because they didn't get the jury instruction given to the jury on this question, so they would get a new trial. Is that the point?
Justice Tannenbaum, I don't think that the entire judgment would be reversed because there were 2 claims. There's a medical necessity claim that they brought forward at trial and lost, and then there is this patient brokering kickback claim. So I think that the judgment of the jury, the decision of the jury with respect to the medical necessity would stand, but then there would have to be either a trial or the summary judgment motion with respect to the kickback issue.
And on the kickback issue, it's because was there evidence that wasn't presented, or is it because the jury would have come up with a different verdict potentially if there was another instruction?
Well, the evidence was presented. It was a 3.5-week jury trial, and they spent 2 days presenting evidence that they think showed kickbacks and patient brokering being paid for these patient referrals. We obviously put evidence in response because they said, well, that rendered the services unlawful, and the jury disagreed with them. So all of the evidence was presented to the jury. It would just have to be, I guess, presented under a different argument and a different theory of liability.
Would it just be what the district court noted in its order granting the stay? In this case, it is
Correct.
essentially either retried or summary judgment granted in favor.
Correct, and I had mentioned that earlier. I think that's exactly right. It would have to go back just for that one particular claim, and there would have to be a decision on whether State Farm would prevail on that. But again, we don't believe that's the appropriate interpretation of the statute because they're effectively asking you to rewrite it.
All right, you still have 2 more things on your list of 4.
I've actually already covered them, so I'm okay, and there's 20 seconds left, so I'll end early unless the court has any other questions. Thank you very much.
Thank you.
Thank you. 4 brief points. The first is on the primary definition. Black's Law Dictionary actually defines the primary definition of responsibility to be a quality, state, or condition of being duty-bound, answerable, or accountable. And so the first quality is duty-bound, not answerable or accountable. As far as American Family is concerned, that turned on a state law issue of whether or not somebody was legally responsible in terms of being a keeper of the animal. And a keeper is somebody that undertakes to manage, control, or care for the animal. So again, implying a duty. As far as the exemption being satisfied at all times, the Agency for Healthcare Administration takes the view that it must be. And we cite those provisions in our brief, that the exempt status must be maintained at all times of operation, and that when they don't satisfy the exemption, the facility's exempt status expires, it negates its qualification for the exemption, and would have to apply for a license. As far as ignoring all laws is concerned, we're not doing that. We're simply saying that you have a duty for all laws, but a violation of a single law doesn't demonstrate that somebody failed in their duty for the entity's compliance. And finally, as far as the comma is concerned, that has never been viewed as dispositive under the series qualifier canon. This court and the Supreme Court has said that it is simply evidence. In Paroline versus United States and United States versus Bass, the U.S. Supreme Court applied the series qualifier canon in the absence of a comma. And finally, I'll note under the legislative's history, as originally enacted, the statute included a comma. It said comma so long as instead of the if clause. Technical amendments were made in 2012, but there's no indication that the legislature meant to change the meaning of the wholly owned exemption.
Can I ask one more question on that, Chief? So if you look at sub F and sub G, the structure in terms of the post-positive modifier is replicated. The commas are absent in both of those structures. So why would we not treat it as this isn't a parallel structure the way that the statute's organized? Why would we not look at it?
I think subsection F demonstrates that the legislature had concerns even for licensed practitioners that they had to have a duty to supervise their clinic, and it would show the absurdity of a construction where you drop that requirement only for a wholly owned clinic, that they could essentially delegate all responsibility to a lay person while avoiding the licensing requirements. And so for those reasons, we'd ask that you answer the certified question from the 11th Circuit by reading legally responsible for the entity's compliance to impose a duty for compliance, and that you resolve the question by construing the statute with the series qualifier canon. Thank you.
Thank you very much. Okay, our next case is Hubbard versus State of Florida, number 2024-1522.
Good morning. May it please the court, Mr. Chief Justice, Craig Trocino and Michael Gottlieb on behalf of Mr. Hubbard. This case is not about elections or the severity of the alleged crimes. This case is about constitutional authority and the constitutional allocation of power. The Office of Statewide Prosecutor is a creature of the Florida Constitution, and when that amendment was enacted, the Florida Constitution put the Office of Statewide Prosecution in a constitutional box. And that box has borders, and this case is about exceeding those constitutional borders. This court has held for quite a long time, most recently in the Ham decision, that the interpretation of constitutional amendments is based upon the supremacy of the Constitution when it conflicts with state statutes. In the Planned Parenthood case, this court has stated that when we interpret those constitutional amendments, the plain text of the constitutional amendment is interpreted by the text, but specifically by what the voters would have interpreted the text at the time it was ratified. The statute was ratified in 1986 by the voters of the state of Florida, pursuant to the Constitutional Convention, directed by Governor Graham, and in that created the Office of Statewide Prosecution. All of the debate, editorial, discussion at the time was about the Office of Statewide Prosecution investigating and prosecuting complex, organized crime. Nowhere in any of that discussion or in the minds of the voters in 1986 was there a discussion of single circuit voter cases being handled by the Office of Statewide Prosecution.
Counsel, how did the District Court of Appeal pass on the question, or how did its decision pass on the question that's been certified to this court?
How did the District Court of Appeal pass on?
How did the decision pass on the question specifically put to this court, which is a very general question of whether the statewide prosecutor can prosecute crimes relating to registering and or voting in a statewide election, which seems to actually be expressly stated in the statute itself?
Well, first off, the 4th District Court of Appeal in this case did not address the constitutional issue at issue. The conflicted cases that are pending the resolution of this, Washington and Hart and so forth, did. The question of whether the statewide prosecutor can answer this, the 4th District Court of Appeal, in our opinion, incorrectly concluded that they could, and they incorrectly concluded it for a few reasons. One, they rested primarily on this idea of effects, the effects jurisdiction.
But that goes to the other portion of the statute, as to whether this activity, happened across different circuits.
Well, it would have to happen across different circuits in order to implicate the Office of Statewide Prosecution.
Sure,
if it's purely
but the general question of whether they can prosecute registering or voting in a statewide election, that's true if the activity passes across.
Only if the activity crosses, correct, yes.
But that's not the question that's been put to us.
The question that's been put to us is, well, not us, Your Honor, and the court, is whether the Office of Statewide Prosecution can prosecute these cases. And the statute...
Generally speaking.
Generally speaking, yes. And it's an overly general thing. And the jurisdiction of this court is once this court accepts jurisdiction on some aspect of it, it accepts jurisdiction on all aspects of it. So I believe the constitutional interpretation that the 4th District Court of Appeal neglected to engage in is squarely before this court.
I think he's asking you, though, because in order for us to have jurisdiction, it's not just a matter of is a question posed, it's did the lower court pass on the question that they're posing?
They did.
Okay, so
Yeah.
so that's what you have to answer.
Correct, and they said it was okay. The Fourth District Court of Appeals said the Office of Statewide Prosecution can prosecute these cases, and it gave reasons why it could prosecute these cases.
Well, but these cases would be in the general category of, because it's expressly listed in the statute that they can prosecute these cases. So I don't understand how that would have been in dispute with the DCA. What was in dispute in front of the DCA was, in this particular case, whether there were facts that showed that the activity crossed judicial circuits.
Well, as it existed at the time in the Fourth DCA, the statute in effect at the time was voter crimes that occur in two or more circuits as part of a related transaction, or affect two or more circuits where there's a criminal conspiracy. That was the statute pre-amendment. That was the statute that was in effect at the time. The stipulated facts here are that there is no criminal conspiracy. So as it existed at the Fourth DCA, without getting into the 2023 amendment, the only question that is germane, because effects doesn't exist, because there's stipulation that there's no criminal conspiracy, would be the related transactions sections. Now, yes, I agree with Your Honor that the statute does seem to say that, but there's a couple of problems, and that's where the Fourth District Court of Appeal, in our opinion, made a mistake. In that, in order to, from a constitutional point of view, in order to activate the authority of the Office of Statewide Prosecution, there has to be multi-circuit impact. There has to be a multi-circuit a transaction, crimes in both circuits in a related transaction. That didn't happen here. So irrespective of what the statute says, if the statute is saying that all voter crimes can be prosecuted by the Office of Statewide Prosecution irrespective of multi-circuit situations, then our opinion is that that would be blatantly unconstitutional.
Why?
But, yes.
Why? What would be unconstitutional about reaching the conclusion that any time a voter crime relates to the validity of a federal or statewide election, it is a permissible subject for the Office of Statewide Prosecution, especially after the 2023 amendment to the statute? What is blatantly unconstitutional about that?
Because the Office of Statewide Prosecution has to have across two or more circuits. I understand.
So let's stipulate, right, that
okay.
Unless you're going to make the argument that the disenfranchisement of one voter is not a statewide effect in a federal election, because we have to reach some level or sort of tipping point of votes for this to count. It would seem to me that if in fact it is a statewide or federal election, the improper exercise of the franchise, which has the effect of disenfranchising others on even one occasion, would be a statewide effect. Tell me why that argument, which the state makes, is somehow unconstitutional.
Several reasons. First, the state did not preserve that argument. They never argued that.
That doesn't go to constitutionality. Why is the argument? You said blatantly unconstitutional.
Because the effect. Now, in order to answer Your Honor's question, and getting the temperature of the room here, I think this is what it all comes down to, is how do we define the word effect? Your Honor is saying that any incorrectly cast vote, therefore, must affect all other circuits. I'm
asking you to tell me why it doesn't.
Right, I'm getting there. I just wanted to make sure I understand Your Honor's question.
Okay.
Right. That is far too ephemeral and tenuous for the purposes of the statewide prosecution. For instance, as Judge May said in the dissent in the 4th District Court of Appeal, if that's the case, then any driver's license offense is statewide. If that's the case, if that's the case, a workers' compensation fraud will affect.
Your position is that I think we're getting a field of an election, right? An election has a statewide. Let's stipulate we're talking about an election for governor.
Okay.
Okay. You're telling me that's not distinguishable from driving with a suspended license from Leon to Alachua County And, you know, I mean, it would seem to me like one clearly has a lasting impact on the outcome of an election. We've seen pretty close elections in Florida. You know, it would seem to me like we can distinguish the driving without a license. You're saying that those are indistinguishable from your perspective?
I'm saying that the concept that one isolated vote has a broad effect statewide, as the 4th District put it, would diminish the public's confidence in the outcome of the elections. If we have that, and I understand, and it's a concern, I'm not trivializing this. I opened with saying this is not about the seriousness of the alleged offenses. However,
what I still haven't heard is why it's blatantly unconstitutional for the Office of the Statewide Prosecutor to try.
Because the test on whether, under the statute, under the Constitution, the test for whether the Office of Statewide Prosecution can act is not whether there's a reduction of public confidence in a particular realm. It is whether a crime was committed in 2 or more circuits, or a crime was committed that affects 2 or more circuits if there's a criminal conspiracy. That doesn't exist here.
Can we just get, I think, let's make sure there's a meeting of the minds here. Okay, on the constitutional side, there's the occurring in 2 or more circuits as part of a related transaction,
correct,
right? That has nothing to do with effects, and has nothing to do with the 2023 statute.
Correct.
The second part of it is, if the 2023 statute is essentially implicitly saying that us voting in a statewide election has effects in more than one circuit, then that might raise a constitutional issue, right? So but for us to even worry about effects, we would have to think that the 2023 statute applied. And so can you just can you focus on the first part, which I think is really the heart of this thing, which is the occurring in 2 circuits or more as part of a related transaction.
Okay.
Which I think is sort of that's kind of the threshold thing, and then in order for the effects thing to be relevant, we'd have to decide that the 2023 statute applies, and that's a completely different constitutional question, right?
I agree. Yeah, so as far as the related transaction is concerned, I don't believe there's a case in Florida where related transaction jurisdiction was found to have happened where there wasn't criminal activity in both. The state relies on King, and the state relies on Snyder. And in both of those cases where the related transaction jurisdiction, if you will, for lack of complicating the issue, where those were found, there was criminal activity in both circuits, in both disparate circuits. Here, it is stipulated in the stipulations at trial that there was no criminal activity in Leon County. Nothing happened in Leon County. If the alleged facts are true, the second Mr. Hubbard picked his pen up off the page after signing the document, that crime was complete. The second he filled in the bubble on the voter card, that crime was complete.
And you would concede he could have been charged right then, arrested right then, correct?
He could have. In fact, I'll go one step further. Let's say that there was an organization who was collecting voter registration cards, and they had a stack of them, and they brought them back to the office, and Mr. Hubbard's fell off the top of the desk and went underneath. The rest of them got sent to Leon County. 3 months later, they find Mr. Hubbard's. He's still potentially guilty of this crime because it finished on the signing. Nothing in the statute in which he was charged with requires any conduct in Leon County whatsoever. The problem we have is the state and the OSP is attempting to fashion a situation where OSP jurisdiction exists by virtue of using a ministerial function where the Secretary of State is discharging its statutory obligation.
So what's the test? You say criminal activity. And what gives meaning to the word occurred? I think Judge Atkinson, in his concurrence, frames it as where the elements of the crime occurred.
Correct.
Do you think that where criminal activity and the elements of crime Is there any daylight between there? Is that just two ways to say the same thing?
I think it's two ways to say the same thing. I can maybe envision a situation where there is still some criminal activity that might not be related. For instance, in the Thatcher case, where the defendant never left Miami-Dade County, but they were importing drugs from, I believe, New Jersey, and the unindicted or the uninformed co-defendant was on a bus with the contraband through the entire state of Florida. So even though that wasn't conduct by Mr. Thatcher, it's still criminal conduct that actually happened in other jurisdictions. Actually, the Winter case is the Snyder case is really instructive, because that was a chop shop, right, where the items were stolen in one county to be fenced or sold in another county, and then in the same county there were also burglaries, totally local burglaries, that the OSP put in there and charged with. And the court said that's okay because it was all part of this related transaction of making sure this enterprise of the chop shop stays afloat. And so that you couldn't separate them. But still, the moral of that story and the moral of King is that a crime or criminal activity actually occurred in both circuits, which is the necessary thing that's the necessary border of the constitutional box in which the Florida Constitution places the Office of Statewide Prosecution. The whole point of the Office of Statewide Prosecution, if you look at some of the amicus briefs, is that Florida decided, the various states' attorneys decided it was really difficult for them at the time to prosecute cases that spanned, especially in organized crime, that spanned circuits. That was the genesis of this complex RICO, complex organized crimes that span circuits in order to more easily and effectively prosecute them.
I mean, the challenge for you, though, is that I think it can't be disputed that the language is broader than what appears to have been the motivation for the creation of the office. Like, it seems like all the materials are organized crime, organized crime, organized crime, and yet the words here in the Constitution are not limited to that, which is what has led to this dispute, right?
Yes, except the one issue that's not in dispute is the multi-circuit aspect of it. And when we look at the case law that addresses what the related transactions in multiple circuits are, there is always a situation where in that other circuit, criminal activity happened.
I know you're already into your rebuttal, but could you just briefly address why the 2023 amended statute would not apply to Mr. Hubbard?
Several reasons. One, it was enacted after the dismissal. Two,
let's stop you right there. So this is dismissed without prejudice, right?
Yes.
Okay. The statute of limitations has not yet run, right?
I don't believe so.
And he's waived speedy trial, right?
I don't know the answer to that question, Your Honor.
What's to stop the state from recharging him pursuant to the 2023 statute?
My next point on that will be Section 775022 says that any amendment of a criminal statute shall operate prospectively only, whether it's procedural or substantive, unless the legislature specifically says so. And this is a criminal statute without getting too far.
Not really. I mean, this is authorization for the statewide prosecutor. This is not defining a criminal offense. 775022 says an amendment of a criminal statute that deals with criminal law in any way over the crime and the punishment. One cannot have a punishment of a crime without prosecution. Therefore, a statute defining the parameters who can prosecute when, how, and where is most certainly a criminal statute.
But I mean, in the what he's talking about, though, if it were to be refiled, then that would be a prospective application because it's a new prosecution, and then you would be able to litigate at that point whether what the effects thing is and all that. But that would be the appropriate time to raise all that.
I understand the court's point. I'm not necessarily willing to concede that that's the particular fact, but I see what Your Honor says, and that would be a reasonable conclusion of that situation, yes. But the fact of the matter is we're not there yet. We're here, and we have the constitutional confines of this, and there is no other activity in another jurisdiction, and I'm way into my rebuttal, so I'll save the little time I have left for that. Thank you.
Thank you.
Mr. Chief Justice, and may it please the court, I'd like to start, if I could, with Justice Tannenbaum's question about your jurisdiction to decide this case. So 2 things on that. Number one, I think the question about the certified question is probably academic, because at this point there's an express and direct conflict amongst the districts. So the relevant point in time for assessing your jurisdiction, we think, would be when you issue a decision here, either quashing or approving. So we think you're good on jurisdiction. And the second point on the QPI would be that you could rephrase the certified question if you thought you had to. I agree that it was perhaps inarticulately worded and perhaps too general, but we think that you would have jurisdiction.
But I mean, if the passing on, I mean, I don't want to get bogged down in this, but if the passing on thing could just be fixed by us rephrasing the question, that would kind of do away with that limit on our jurisdiction, right?
I understand that, but I think the court does have this practice of rephrasing certified questions. I think it's a sort of functional approach.
Right. Okay. I don't want to get you off.
But it's not just, and just because it's been the practice in the past. I mean, the fact is that under the 1968 Constitution as amended, the DCA has been made in a bunch of circumstances the gatekeepers for our jurisdiction. So if a DCA certified a question and we said, well, you asked the wrong question, so we're going to do this other thing, doesn't that reanimate the cert jurisdiction that was eliminated in early 1980s?
I think my point about that, Your Honor, is that we know what they meant to certify, and we know they passed on that. But if you have any concern about that, just look to the conflict here, which I think is pretty obvious between the 3rd and 4th and the 2nd and 6th.
So is the actual question, is the import of the DCA's decision potentially that there's no distinction between basically any state registration or any voting is going to have impact across circuits? So the question is that true, or is there a distinction between there actually has to be a specific showing across circuits, like opposing counsel has argued, as opposed to if it is a voter registration violation or a voting violation, it necessarily implicates the OSP's authority to prosecute?
Yeah, Justice Tannenbaum, I think the way that the lower court analyzed the question was that if you vote in a statewide election for statewide officer or for constitutional amendments, that will necessarily have an effect across the state. That seemed to be the import of what the court said, and they passed on that question.
Doesn't that render the second part of the statute then superfluous? Why put in the provision about the office shall have such power only when it's occurring across? I mean, why not just list it the way the first part is and dispense with the second part?
So I think the legislature just wanted to be clear that it was tracking the constitutional text, and a requirement of the constitutional text is that you have the related transaction or you have a multi-circuit effect. And now I would think it's possible there are some categories of crimes that will always have a statewide effect, and this would certainly be one of them. So
can you focus on the first thing, because the effects thing is only matters if the 2023 statute applies. Do you agree with that?
Yeah, that's certainly right.
Okay, all right. So
let's start at the beginning.
Let's start at the beginning, because
Sure.
Everybody agrees that the occurrence thing is potentially on the table, right?
Yes.
Okay. So
there's no doubt that the occurrence prong
that
was in the
pre-2023
That was the theory
amendment under which this person was prosecuted
that's right.
in the beginning.
I mean, obviously I want to talk about both, but on the related transaction prong, I'm happy to lead with that. So we think we've got a pretty clear related transaction here. There's nothing in the statute or the constitutional text that requires that every piece of the transaction be criminal in nature. The Radvars could have said that. They could have said a related criminal transaction through and through, but that's not what they said. So I think Mr. Hubbard's position before today was that the only way you could have a related transaction was if the elements of the particular crime happened in 2 or more places. I don't understand them really to be making that argument today. I think their argument today is a little bit more like what the second DCA said in Hart, that you have to have a transaction comprised of multiple crimes which happen in different places.
So the way that Tricino makes the argument that, even if the voter registration paperwork had been lost under a table,
right,
you could still charge the person. It seems like he's arguing, in fact, that there is no additional transaction required. The crime is complete. How do you respond to him on that?
Well, that's not, so I think insofar as it goes, that would be true for that particular crime, but it's not true of the entire criminal scheme here, because his objective was not merely to register to vote. He did that for a reason, because he wanted to vote in the 2020 election illegally. The only way that he could do that was if he first convinced state officials to place him on the voter roll. So to do that, he had to submit the false attestation down in Broward. By statute, the supervisors take that information, they send it to the secretary here in Leon County, and there's a statutory process for verifying that information and then putting the person on the rolls here in town. Only then could Mr. Hubbard complete the criminal scheme by going back to Broward and voting in Broward. The entirety of that is a related transaction. As the
So we have, this is the rare, I know this isn't technically a hearing on conflict, but this is the rare situation where we actually have great opinions below that are grappling with the issues directly, right. And so it's not the usual, like, no one was talking, nobody was talking to each other and we say there's a conflict. So right. You have the 2nd and the 6th DCA that both seem to hinge their analysis on the idea that the crime has to occur in multiple circuits, and then I guess the 2nd says it can be two crimes that occur in a single as long as they're related, and the right. 6th is kind of narrower and says that the one crime has to sort of have, be committed in 2 circuits or whatever. So, but it seems like for you have to sort of deal with that issue of the crime occurring in the 2 circuits, sort of to kind of get past them, because it sounds like you're sort of relying on are you saying that what's happening in Leon is part of what makes the crime occurring, or is that a completely just a related transaction argument?
Yeah, so the way that we read this to give effect to the text about the related transaction prong is that we know the crime has to occur. How does it have to occur? There are 2 adverbial clauses that modify that verb. One is in 2 or more judicial circuits. The crime has to occur in 2 or more circuits. How does it do that? It does it as part of a related transaction. As part of a related transaction modifies the verb in the first adverbial clause. They all work together. If that weren't the case, it would be quite odd so the theory that we understood them to have briefed and that the 6th DCA espoused, if that were the case, that you actually had to have elements of a single crime happening in more than 1 circuit, that would be a vanishingly small number of circumstances. So the King case out of the 5th DCA made this point. One of the original enumerated crimes in the 1985 implementing legislation was burglary. Well, unless the burgled property happened to sit on the circuit line, you would never have a burglary whose elements happened in more than 1 place.
When was burglary amended to include conveyance? Burglary of a conveyance?
It probably did. I'm sure it included conveyance at that time.
So, because there's at least one old case where somebody burglarized a car that moved into a different judicial circuit, and then you look at the statute saying where to charge crimes that have occurred in multiple judicial circuits. So I could see how burglary might fit, even though most burglaries are probably local in nature, within kind of this multi-circuit scenario.
Yeah, and Justice Sasso, there might be a home that sits on the circuit line as well. I mean, our point is that that is a true outlier that I don't think anybody in 85 or 86 would have thought the ratifiers had in mind. They had in mind something broader. Homicide works the same way.
I mean, the reason you're bringing this up because the statute lists burglary.
Right. So
but I mean, the text doesn't, so maybe burglary shouldn't be in the statute.
The point that we're making is that contemporaneously with the enactment of this constitutional text, there was an implementing statute right around the same time, and the legislature understood that burglary would be the kind of crime that you could prosecute under the related transaction prong.
So should we also read the organized crime limitation into the Constitution too?
No, I'm just saying that, a well-informed body, the legislature, looking at this constitutional text, thought that burglary would be prosecutable by the statewide prosecutor. So I just think it's one indication of the meaning of the text.
It just feels very different to say, even under yours, where you have burglary, maybe they're fencing the items in another place, and maybe they're transacting money in a conspiracy in another place. I mean, I can see how there might be individual offenses that are happening in each circuit, but it's part of a related transaction, and perhaps that would be it. What you're saying is someone committed a crime fully, All the elements of the crime were met the minute they signed the thing or went in to the polls. But yet, because of a sort of administrative aspect that this person technically had nothing to do with, that somehow ropes this into being a related transaction. And I think that's where we're all having a little bit of a difficulty. That doesn't seem to be offense is occurring or has occurred in 2 or more circuits.
Right. So
what
I would
is
say
the
with
offense that he committed that is occurring at his own behest, other than an administrative checkoff?
Well, no, look, I think all the parties agree that the elements of the crime happened in one place, in Broward. But as the 3rd District said in Miller, to complete the crime, there were things that were necessary that had to happen
So you
elsewhere.
could not charge him with this crime if it had not gone to Tallahassee. You're saying the state cannot charge this particular crime if that is not processed in Tallahassee?
At least not under the related transaction theory. Obviously, under the effects theory, we have a broader
you just
claim.
said that he hadn't completed the crime yet. So has he completed the crime or not?
No, what I'm saying is, okay, if you're just talking about the elements of the crime, those elements happened in a single circuit. Our point, though, is that the text is a related transaction. And in order to, and this is what the lower courts that rule for us are saying, in order to have completed his crime in the practical sense, not in the literal sense of where the elements happen, but in the practical sense, he had to get some buy-in from the Secretary of State to verify his information and put him on the rolls. Without that, he literally could not have voted illegally in the 2020 election.
But he could have
That's the related
registered. He could
transaction.
have false swearing submission of false voter registration.
Yes, but that is not all that he did. He also then went on to vote, and to vote, he needed the Secretary's acquiescence.
So if someone votes improperly under this law, but for whatever reason the Secretary of State hasn't processed. So let's say they go in, they say you're not on the roll, but you can go ahead and cast your vote, right? That happens, and then we'll check it later, right? That happens a lot, I think. Are you saying they didn't commit a crime then because they hadn't been processed in Tallahassee yet?
So I think you do have to be on the rolls. There's a.
She's talking about casting a provisional ballot.
The provisional,
and then it gets
you are on the
verified.
rolls.
So you would say the scheme then was completed when the provisional ballot was verified with the help of Tallahassee?
Well, even then, I don't know. No, I would phrase it differently. The transaction was when they put you on the rolls to begin with, because without that, you couldn't even vote the provisional ballot.
So I guess
What happens if Mr. Hubbard had committed a crime?
If he had committed his crime in Leon County, we would be talking exclusively about the effects prong, and we would have arguments under the effects prong.
Also, okay, so assuming that statute's not in play, there would be a crime committed in Leon County that's transmitted to the Secretary of State, who's located right behind us right here.
No, the related transaction would have happened in Leon County.
Did the legislature intend for Tallahassee to do it from the hands of the statewide prosecutor?
Well,
I mean, the legislature?
This might be a quirk of how the related transaction
Well, they
prong
know all
works.
these things, the legislature. I should have thought about this.
I would just ask yourself, does the text related transaction, was there a transaction here between Mr. Hubbard and state officials? If there was, and if it happened in 2 places, that's enough.
The only reason we're here, putting aside the 2023 amendment, we're here is because cast his vote in fraud in County, and there was some middle Secretary of State, and that brought in second circuit. Now we have 2 circuits. Now, my hypothetical, he committed his crime in Leon County, so same county, the transmittal. So did the legislature meant to leave that out? How did that work?
Well, I don't know what they meant, but I know what the words that they used are, and we think that our reading is the most reasonable reading. Now, I want to say one more thing about the related transaction prong, and I do want to talk about the 2023 legislation. So the other theory that's out there in some of the district courts, the second DCA, Judge Atkinson's opinion does a nice job laying this theory out, is that the way that the related transaction prong works, you don't need elements in 2 places. You need 2 separate crimes, one in one place, another in another. And he got there by looking at the use of the plural in violations of criminal laws. We think the problem, and so we reasoned, okay, there has to be violations, more than one. We think the problem with that is because the plural always includes the singular. So when the text uses violations, it really just means any violation of a criminal law, and that's confirmed in two places. After the comma, when we get into the effects language, the text uses any such offense in the singular, and that's how the legislature understood it as to both the related transaction and effects prongs in 1985 in the implementing legislation, because it said when any such offense. So the legislature seemed to think you just needed one offense, not more than one.
Why would we not, in defining what constitutes a transaction, look at the statutes of the crimes that were charged to guide us on what the transaction was? And here, if it's just willfully votes or willfully swears or affirms falsely in any oath or affirmation, why should the statute of the crime charge not be our guide in defining the transaction, as opposed to this kind of bigger picture? And again, effects would be a completely different scenario. But it seems like we have to go beyond the statute that describes the crime to work in this idea of a transaction.
Well, I think sometimes it would be helpful to look to the elements to figure out where the thing happened, but we think that the transaction would not be limited to that. And I think your question kind of assumes the answer to the interpretive question about what is it that we look to figure out where the related transaction is. So for us, it's as simple as, do you think that there was a transaction here between Mr. Hubbard and state officials in Leon County? And if you think that there was and that it was necessary to the crime, then we should win on this theory.
But on that point, there seems to be a little bit of a misunderstanding on how two statutes in particular operate. 102.071, which has to do with tabulation of the votes, and 98.015, which has to do with registration with the supervisors of election. So the supervisor of election is a constitutional officer, and they are made responsible. They're voter registration officers, and there's a whole statute that governs how they do registration. They can have their own software system, and all that happens is that then they have to send the name to a master database that's managed by the Secretary of State. But that's not, and then the confirmation or the issues about whether they're a convicted felon or there's duplicates, that happens after the registration is final. So on that front, it seems like it's done when the supervisor of elections takes that registration. And then on the voting side, the tabulation happens at each precinct. And then the election board for each precinct reports the votes to the canvassing board for the county. And then those votes are then counted and collected and then tabulated into a number. And that's their vote for each county. And then that certification then goes to the Election Canvassing Commission eventually, to be then finally canvassed. There seems to be a lot of things that happen in between the actual acts and Tallahassee getting involved in any sort of active way.
Justice Tannenbaum, I'd rely on a statute that's much more immediate and in between all of that, and that's 97.053 sub 6, which says that before you can be placed on the rolls, within a certain amount of time, the secretary has to verify. I think it's like the secretary has 13 days or something like that to verify. And that happens before you can ever vote and before you can be placed on the rolls. It says that a registration application is only valid if the secretary verifies.
Right, but doesn't the supervisor election still put the registration into the system, and then it eventually transmits to the secretary?
But it's only valid if there's the verification. So I think we would rest on that for the application.
So is it, go ahead.
Hold on, please.
But the false statement is made to the supervisor, right?
Yes, but you cannot vote unless you have the verification.
Right. So under just that follows with under just the false statement, you were saying that would not be an occurrence. There would be no occurrence jurisdiction of the statewide prosecutor.
I think that's right.
Okay.
We're not saying that. This is bookended on the one side by the whole scheme is bookended by the false statement and then by the voting.
So if it was just false statement,
we don't have to address what would have happened with just one or the other. I'm sorry to cut you off.
That's okay. So just the false statement, not necessarily, because that's not a Tallahassee involved process.
I don't have to take that on today. I'm relying on the fact that all of this was part of the transaction. Now,
I just wanted to pivot us in a slightly different direction that I think speaks to this a little bit. The word concurrent appears in Article 4, Section 4B. It's concurrent jurisdiction, right? If that word didn't appear and we were speaking only about jurisdiction, perhaps we would have more concern about whether the Office of Statewide Prosecution was displacing the local state attorney's office. My question, my sort of last line of questioning that I wanted to get the state's view on is, do you agree that at most what the Office of Statewide Prosecution has is the same jurisdiction, not any greater jurisdiction than what the state attorney's office has? That's the first sort of thing I wanted to gut check.
Concurrent would suggest that.
Okay, so if that's true, then all of this debate we've been having about, whether it has jurisdiction or not based on the occurrence of a transaction that didn't include criminal elements seems to me, at the end of the day, we're not saying like the crime did or did not happen. We're just saying whether one or two entities have the jurisdiction to prosecute the crime. We're not going to the sort of operational decision of whether or not a crime has been committed. We're just saying, and conceivably both entities could prosecute the crime, right? Like, it'd be an interesting question if both the state attorney's office and the Office of Statewide Prosecution had prosecuted Mr. Hubbard. It would seem to me to be sort of almost like a, discretionary decision about which of the two cases would be allowed to proceed. And that's really what I wanted to end on is what's the state's position on what would happen if both the state attorney and the Office of Statewide Prosecution had sought to prosecute Mr. Hubbard?
Well, that's an interesting practical question. I think, generally speaking, we would try to work it out and figure out. It might just be a team effort, or we'd negotiate something. But as a legal matter, I'm not sure what the answer would be in terms of how that would shake out if there was some disagreement.
Can I clarify something though? So, under the 6 DCA Ganem view, because you have to have elements or some aspect of the one crime that occurs across circuits, right, then either one of the state attorneys in those circuits could prosecute that, and the statewide prosecutor, under the Atkinson view that you can have Circuit 1, Circuit 2, but they're part of a related transaction, then each state attorney would be limited to prosecuting their one crime. Right?
I'd have to think more about whether that would be correct, but there could potentially be 3 constitutional actors involved.
You know what I'm saying? So let me ask you, though, and we'll give you 2 minutes to talk about the 2023 thing. If we disagree with you on the occurring in 2 and the related transaction, do you agree that we could decide basically that this prosecution isn't authorized by the Constitution and sort of leave for another day adjudicating the Atkinson versus Ganem fight over whether it has to be, the two crimes in different circuits that are related versus the one crime in 2 circuits that also has part of a related transaction?
Like, platonically, could you do that? I suppose, although you would answer the interpretive question, I would think, and in doing so,
we would be answering part of it. We just wouldn't need to lock ourselves in, because you would lose under either one of their approaches.
Right. I think it might be a bit of an unsatisfactory opinion if you just say, look, the state's wrong. We don't know what the real meaning of the text is. The state is just wrong.
Well, we could wait for a case where it mattered. But anyway, if you could just spend 2 minutes on your 2023.
Thank you for that. So I think the real crux on the effects prong is whether or not the new legislation applies. I think we're on very strong footing that we would have an effect in more than one place, not just statewide, but even just being placed on the rolls or casting a vote. Like, that is a concrete, cognizable effect in more than one place. So it's going to come down to whether you think Chapter 2023-2 applies. And there, the case law from the U.S. Supreme Court is so persuasive on this. United States versus Alabama is almost on all fours and lays out this background, this default rule against which legislatures act. So in United States versus Alabama, the United States brought a civil rights action against Alabama, and the district court dismissed because at the time the civil rights laws in this country didn't authorize that suit against the state. For the first time on appeal, after the U.S. Supreme Court had granted cert and right before it argued the case, Congress changed the Civil Rights Act to authorize the suit against the state. And the U.S. Supreme Court said, we are going to apply the law that exists right now and approved that suit to go forward and had to reverse the lower courts. So that's the background principle, and there are plenty of cases like this, Bruner and Andrus and Landgraf, that we've cited that espouse these principles.
Could you tell me, because this is kind of a very state-specific kind of question of procedure, what was the error that the lower court made that the fourth DCA addressed and reversed?
So strictly speaking, it's an error in dismissing our prosecution.
But they didn't address that, correct? Because they then addressed effects and the new statute, neither of which were available to the lower court.
Well, I think the fourth DCA ruled for us on both theories, but yes, they passed on a question that necessarily wasn't in front of the circuit court because the legislation hadn't happened yet.
So you think that that's kind of an unusual situation for an appellate court to render a reversal based on a complete lack of error by the trial court?
That is United States versus Alabama.
What about Love, though? Our case.
Yeah, so I think the way that it fits into the framework from Love, which I think, Landgraf and all these other cases are part of, is that we have to have a prospective application. Our whole point is that this criminal prosecution is not over. It is ongoing. We are still prosecuting him. We just happen to be appealing a dismissal order, but a criminal prosecution is not final even when there is a conviction until the appeal. So this is still very much a live issue, and all we are asking the court to do is recognize that in an ongoing prosecution, if there is a statute that grants jurisdiction, it applies, as in Alabama, as in the many jurisdiction stripping cases that are out there like Bruner and Andrus. So we think that's a fairly well settled principle. Landgraf said that the court had regularly applied intervening statutes that oust or grant jurisdiction.
So why would we not, though, as the law changes, drop it down in the case, procedurally where it is, as we do in Love? I mean, it seems to be a different scenario than the Alabama case. So in other words, if this proceeding has already occurred, now we're in appeal, it applies going forward, but the events that happen that would be applicable to, those are done, those are gone. We're not going to retry every case in Florida every time the law changes.
So I disagree that it's different from the Alabama case. In the Alabama case, the federal district court dismissed the complaint because the suit wasn't authorized against the state. And then Congress changed that after the cert grant in the U.S. Supreme Court, and the court said, we're sending the case back, the case can proceed. So I really do think it is on all fours. Now, as a practical matter, and this is one of the reasons that we say this is academic, this might be motivating this whole line of cases. As a practical matter, the worst thing that happens here is you say, well, we're not going to apply it, go back on remand, or no remand, and then we just refile under the new legislation and we get to proceed. And opposing counsel has said that there's not a statute of limitations problem here. So we could do that, but we think that this case law just reflects that there's no need to do that, because given that the new state of the law would apply to any new suit prospectively, you could just apply it here and save everyone the additional labor.
Principle, though, we would have to, it doesn't matter here because of the statute of limitations not running, but there could be cases where it would matter.
Well, I suppose that could be true. I'm just suggesting that this is an explanation for doctrinally what all these cases like Alabama are doing. It just kind of goes
also,
to...
though, I mean, it also gives, ideally this is the kind of thing that would be litigated in the trial court, and you'd have to say what the effects are, and, I mean, in a perfect world, you wouldn't be having this kind of appellate court sort of like, oh, no harm, no foul, kind of move on sort of thing. I mean, this is a relatively straightforward case, but you can imagine a lot where it might not be.
Well, I agree, but I think you take the case as you find it, and this is a case where they're disputing the legal consequences of the points that we make, but they're not disputing that the votes were cast and the vote had to be tallied and that there would have been this effect. They just think that's not an effect that's cognizable under the Constitution.
Well, what they're really asserting, I mean, Article 1, Section 15 gives Mr. Hubbard the right to have an information filed against him that is signed by an authorized prosecuting authority. And at the time, the argument was, under the existing law, that the statewide prosecutor wasn't authorized to sign that information, which substitutes for a probable cause determination. So that's the right that's being asserted, and the trial court at the time agreed and said that this information is not authorized in enforcing that right. So how would we just say, well, But now the law's changed, and so everything's okay, even though at the time it wasn't authorized.
Well, that's a sort of notice due process theory. You have to be put on notice of the state's theory of jurisdiction. I don't think there's any dispute, Justice Tannenbaum. They're on notice. We've been litigating this since the fourth DCA. So what happened in the fourth DCA, and I know I'm well over my time, but as soon as the law was enacted, we asked for relinquishment to the state circuit court so that we could litigate this question, get a ruling in the first instance, amend our information, do the things that we would do on remand here. And the fourth DCA was happy. It was content to proceed with the appeal. So he's had his opportunity to make every argument that he would have made in the circuit court. He hasn't identified any other claim that he would have raised if he'd actually done this in front of the circuit
But the
judge.
state could have also just dropped their appeal and refiled under the new statute.
Well, we could have done that, but we wanted to press the related transaction prong, and I think there would have been some sort of sticky questions about whether we could do that after having voluntarily dismissed an appeal or that issue was presented. So we did not view that as being a route that we could take.
Does anybody have any other questions? Okay, thanks a lot.
Thank you very much.
Can you put 5 minutes on there total?
I appreciate that, Your Honor.
Thanks.
One of the things that counsel said that struck me is that in order for this to be a related transaction, the Secretary of State had to have buy-in. Now, as Justice Tannenbaum was saying earlier, that they're basically doing a statutory function. Buy-in requires, I agree, let me go and do this. But what it isn't is just a ministerial function. There's no change in circumstances. They're not using any discretion. They're not changing their minds. They're checking a box and sending it off.
Can you address if we found the 2023 statute does apply? So far, your argument for why it doesn't affect is based on kind of this parade of horribles sort of results-oriented. And so I'm wondering what textually, structurally, what would we look to limit effects jurisdiction? And if it's so vague that we can't say that there isn't room for prosecutorial discretion, you're asking us to say something that's essentially unconstitutional. Don't we need to, as Planned Parenthood said, you've already cited that case, kind of find that beyond a reasonable doubt?
Yes, well, I agree with, I think what Your Honor was asking counsel earlier was about the Love case and how Love would control this situation.
Right, but assuming we've gotten past that.
Yeah, then I think the words in statutes have to have a meaning, right? And so if we use the word affect, can the word affect without, the difference, let me step back. The main difference, the only difference between the statute and the 2023 amendment is the removal of criminal conspiracy. Essentially, that was it. And that was done after the legislature realized they must have made a mistake in this case, or in all these cases. And so when they took that out, now we're stuck with effects, because that's the operative word here. And words and statutes have to have a meaning. And if they're so ephemeral to where they can cast a net unlimited in an unlimited fashion, then that would violate not only the enabling statute from the Office of Statewide Prosecution's point of view, but the constitutional amendment that created it in the first place. Because, yeah, I mean, the parade of horribles, as Your Honor put it, is one thing, but they're potentially real, because what we come down to in this case is the constitutional...
I mean, we could debate about effects all the time, but in terms of limiting the level of generality that we would apply effects, what would we look to do that, besides if we take out the kind of like results-oriented limitation?
It would have to be something internal in that other circuit that affects. Look, the statute, the legislature in the enabling statute, they have a section about internet crimes. And they said a crime that happens over the internet affects all circuits. They knew how to say that when they amended this. They chose not to.
But analytically, wouldn't your answer have to, in some way, you'd have to say that, look, you can't read the effects thing in the Constitution so broadly that it makes the first thing irrelevant.
Exactly.
Right.
Yeah.
And so I think that's at least like a possible sort of gateway for you to walk through. But I still think that it's difficult then to figure out sort of how to put some teeth into the effects thing in any kind of principled way. But if it just literally means any effect, no matter how sort of, tangential or whatever, then there would be no point to having the occurring in two or more related transaction, whatever. Why bother?
Yeah, and teeth and the effects is an appropriate analogy, because I think the effects, in order for this to pass constitutional law, effects has to have teeth. It's toothless.
Well, how about this? Would you concede you'd have a stronger case if the election had just been for mayor of Lighthouse Point in Broward County and he'd voted just for that? Would you agree that your position here today would be stronger?
Well, that would be a situation where it was purely in one circuit.
Yes.
But I don't think it changes the outcome of it at all, because we still need to define effects. What does it mean? What does effects mean? Does it mean that we can have a situation where the 4th District Court of Appeal decided without any record evidence that I'm sure we can all agree, standing here, me standing here, you all sitting here, that fraud in elections is bad and it's a problem. But I don't think we can, other than our gut instinct to say that's got to affect the public's confidence in the outcome of the elections, I don't think we can legitimately make that particular leap here.
Well, but I don't think the state is arguing, although some of the decisions from the DCAs have spoken about public confidence. I want to be clear. My questions are not about public confidence.
Okay.
It's about outcome determination in an election. I mean, we've had elections decided by 438 votes. So I'm not talking about confidence. My question is sort of, I think, an effort to get you to admit, which I think you have, that in a statewide or federal election, there is a numerical effect on the computation of votes that would be different in that it is statewide from a local election alone. And that would seem to be one line that could be drawn in trying to come up with a line for the effects test. Am I wrong about that?
I don't think Your Honor's wrong, but I think there's a nuance in there, and I'm out of time. So
We helped you.
But there's a nuance there in that if we would also need to know for whom this person voted for. If this person voted for a write-in candidate, that doesn't make a difference, even if the margin is 423 votes. So there's a lot of information about the functional activity of this criminal offense that we don't know. And if we take the position that it just sounds bad and it hurts me fundamentally to my core of democracy, that's well and good, but it doesn't rise to the level of allowing the Office of Statewide Prosecution to exceed their constitutional box and prosecute these cases.
Could you please?
I'm not necessarily disagreeing with you, Justice Curiel, but there's a lot of information we don't know in order to get to where you're going.
Yeah, I'm sorry to interrupt you, but last thing, and then obviously if anybody else has anything, but could you address his point about that Alabama case? Because that does, he's saying that they, at the time the United States filed the lawsuit, they didn't have the authority to do it. They gained the authority midway during the appeal. The court said that's fine. Why isn't that what's happening here?
One, it was a civil rights case, so we're dealing with criminal cases. So the protections against for defendants are heightened in situations of criminal cases like the one that we have. Two, I think this court's decision in Love perfectly applies here because that was a midstream case.
Yeah.
And then the change in the burden of proof on those hearings was held not to apply, even though it could have gone back and done it the other way. So I don't think the federal cases are applicable in this particular circumstance.
Okay. Does anybody else have any questions?
So in the end,
Sure.
why can it not be that why can't the legislature ultimately determine, looking at the landscape in the state of Florida, identifying maybe there's certain judicial circuits, maybe there are certain state attorneys that don't want to prosecute certain voter registration issues or voting problems? Why can't the legislature say, hey, we're going, because of the importance to the state of Florida to have, fair elections, accurate elections, to say, look, we have this office of statewide prosecutor. We're going to designate that office, which has, basically statewide authority or multi-circuit authority. We're going to designate that office to prosecute these cases when the state attorney isn't going to bring the case. And because it has implications statewide, voter registration and voting in statewide elections.
Because that would be contrary to the constitutional amendment that created the Office of Statewide Prosecution, where it's required to be in multi-circuits.
But the legislature could kind of determine that, you know, say that, well, it does, by definition, crosses judicial circuits in that way.
They had the opportunity to say that, like they did in the internet type cases, and they chose not to. So the doctrine of statutory construction is if they knew how to say it and they left it out, you can come to the conclusion that they intended to leave it out. And I'm well over my time. I appreciate the court's patience, and with that, I'd ask the court to reverse the 4th District Court of Appeal. Thank you.
Thank you. We'll take a 10-minute recess.
All rise. This honorable court is now in recess. That's all right. Supreme Court of Florida is now in session. Please be seated.
Thanks. Our last case today is Absinu versus State of Florida, number 2024-0048.
May I please the court? This is a case where the jury that decided Mr. Absinu's guilt This is a case where the jury that decided Mr. Absinu's guilt was engaged in egregious misconduct. Misconduct so bad that the trial court agreed that a new penalty phase was required, but refused to grant the defense motion for a new guilt phase. While I stand on all of the issues raised in briefing, today I plan on addressing points 1, 2, and 3, which have to do with a series of errors that occurred because of the juror misconduct and juror interviews into that misconduct, the trial court's interference with the state and defense counsel's agreement that the state would waive the death penalty in exchange for no further interviews taking place, and Mr. Absinu's request to represent himself. In point 1, we are asking the court to reverse Mr. Absinu's conviction and remand for a new guilt phase because of the juror misconduct that took place during the guilt phase.
What do we do with four-person Thorpe's statement under oath that he did not do any research during the guilt phase? Isn't that an adequate basis to support the court's discretionary call? I mean, sitting here as we review that decision, how are we to say that that was not an adequate basis for the trial court to make the decision it did?
So first of all, because the juror Ferguson made a very specific claim about what she observed happened, what she observed Mr. Thorpe say, specifically referencing Mr. Absinu flipping off the jury with the middle finger, which she later learned was something that happened back in 2018. She, in her testimony, Ferguson hypothesized that he had learned about this from research or some other way, was what she said. So the question that was posed by the trial court to Mr. Thorpe was, did you yourself do any research out of court? To which he said no. And then the follow-up question was, did any of the other jurors talk to you or convey information that they researched out of court? And he said no again. That does not foreclose the possibility that he learned this in some other way.
It certainly doesn't, but again, we're looking for evidence that the trial court's decision here was fanciful or not within the range of discretion afforded to a trial court judge. And here we have two very sensible questions under oath to the foreperson of the jury. My question is, if that's not a sufficient evidentiary basis to support the trial court's decision, what is?
I think the trial court would have had to ask specifically about the allegations that Juror Ferguson made. Specifically, was there a conversation about Mr. Absinu flipping off the jury? And I think that's important because the record in front of us reflects that Mr. Absinu was never in handcuffs in front of this jury. And if I could just step back, the specific allegation that Ms. Ferguson made was that Thorpe said he saw Mr. Absinu flipping off the jury while he was being put into handcuffs. So the fact that Mr. Absinu never appeared in front of this jury during the guilt phase in handcuffs is significant to the credibility of Ms. Ferguson and of Mr. Thorpe.
Well, isn't her credibility at issue? I mean, couldn't the trial judge have, as part of assessing the credibility, looked at the fact that this went all the way? I mean, the WhatsApp board was going on for a couple months or whatever, and they go through all the way through, and then it's brought up, as opposed to coming forward immediately. Does that factor into the credibility determination, and isn't that fair game for the trial court?
in the
To
sense...
discount what was being reported initially. I mean, which some of it's hearsay and some of it's conjecture.
In the sense of discounting Ms. Ferguson's credibility? You know, the court can take into a myriad of things in determining the person's credibility, but I think at its core, this was a very specific allegation that she made. That very specific allegation was not put to Juror Thorpe, so his denial did not deny that specific allegation. I would agree with the court that there are multiple things that the trial court could have considered in determining which juror he believed to be credible. But I think without the direct question to Juror Thorpe about Ferguson's allegation, there was no basis for believing Thorpe. The only thing that we have in the record at this point is Ms. Ferguson's allegation. The allegation that Ms. Ferguson made inherently was prejudicial to Mr. Avsnu. If Thorpe had learned about this prior incident that happened during the penalty phase of Mr. Avsnu's 2018 trial for these same charges, Thorpe necessarily would have known that Avsnu had been convicted of this crime before. That is the type of information that this court has determined in past cases to be inherently prejudicial and requiring a new trial. Specifically, this court in Jackson versus State was considering a situation where a witness disclosed that the defendant had previously been convicted of the same crime. This court noted that having the jury hear testimony that the defendant had previously been convicted of the crimes for which he's now on trial is so damaging that it cannot be said beyond a reasonable doubt that the jury would return a verdict of guilty absent that testimony. This is exactly the same type of information that we are talking about Juror Thorpe having been exposed to and having told the other jurors about. Again, the record does not refute Ms. Ferguson's claim that that is what happened. And so on that basis, it supports the defendant's motion for a new trial. The second ground... Well,
again, unless the trial court discounted her credibility in the first place, right?
But I would agree, but the court has to have a basis for discounting Ms. Ferguson's testimony. And
which could include the fact that she waited so long to report this. It could raise some suspicion that she waits all the way through and then brings this up, way past when the trial happened. Like, where was she for the first part? And now that's rhetorical, but the trial judge could have been asking that question too and wondering if she's making up these allegations or whatever else.
Well, so I have two answers to that. The first is that in her testimony, she did explain that she was not actually part of the core jury group and she didn't really understand what was going on, thought people were just making jokes, and it was only afterwards, after the penalty phase, when she did a little bit of research and realized that this middle finger incident was something that happened in 2018, that it then raised the alarm for her. So I think that undercuts the point about her waiting, makes her not credible. The second point there is candidly, I've forgotten the second point.
That's okay.
I would like to move on to the second problem that I see with the juror misconduct that occurred during guilt phase. And that is evidenced by the WhatsApp group chat, where at least 2 jurors are talking about the fact that they prematurely deliberated about the penalty phase during guilt phase. 2 different jurors talked about, to put it into context, in the course of a conversation on the chat about what penalty phase was going to look like and how long it was going to take. 2 different jurors referenced the fact that they had previously voted. Specifically, one juror saying, "I have no idea what the attorney would even say to change or swing the vote, and little do they know, we already know the answer." Another juror responding, "I think by now we all know which way we're voting." And then in this context, a third juror was saying that the penalty phase was only going to take about 15 minutes. sort of referencing that his mind was made up. These comments are prima facie evidence of premature deliberations, in particular because they indicate that multiple jurors had already voted on the outcome. And those are the two sort of specific criteria that this court has identified.
But how does that undercut the validity of the verdict on guilt? I mean, obviously this is a capital case. Jurors know that, and they're deliberating. They come up with a verdict as to whether the defendant was guilty of murder. How does the fact that they may have been contemplating or thinking about he's not just guilty, but he's really guilty, and if we get a chance to go to the penalty phase, we're going to vote for death? I mean, that's clearly a reason why they should have been discharged for the penalty phase. How does that affect the? I don't track how that affects the guilt phase.
So one problem with that is that, we're talking about 12 different people on the jury. So while some of them may have been absolutely convinced as to Mr. Avnew's guilt and were already ready to move on to the penalty phase, that doesn't mean all of them were. So a conversation with people who are, quote, voting about what would happen in the penalty phase would most likely be affecting other jurors who have still not been convinced about the guilt phase. And so but
that would actually help your client, because if there are others that were still on the fence, they may want to do a lesser included or something to avoid that, right?
Well, I think the flip side of that is that if they see other jurors are so adamant about their position, it would sway them to also find him guilty. I don't think that we can necessarily get into the specifics of how individual jurors would have viewed it, but for the fact that it would have affected the group dynamic in the conversation. This court has said that premature jury deliberations are presumptively prejudicial, and the burden shifts to the state to show that they did not affect the verdict. There's nothing in the evidence in the record before us that would suggest that the state can meet that burden of showing that the jury was not affected by the premature deliberations. I think both of these instances of juror misconduct, or Ferguson's testimony about what Juror Thorpe told them, and the WhatsApp text comments about premature deliberations, both of those show that this misconduct reached much further than just the penalty phase and was ongoing as well in the guilt phase. On that basis,
maybe my memory is faulty here, but isn't there evidence in the record that the WhatsApp group was created after the guilty verdict?
Yes, the WhatsApp group was created the day of the guilty verdict, and the particular exchange that I'm talking about happened approximately a month later.
Okay.
It is clear, though, it's all in past tense. They are referring to what has already happened in that text thread.
But the chat itself, like the WhatsApp chat, doesn't get started until after the verdict is already
correct.
Okay.
Right. To the extent that the court feels that the current record does not fully support reversing for a new trial on guilt, I would suggest that the fault with that lies in the trial court for not having granted juror interviews of all 12 of the jurors. He only interviewed 3 of them. And those 3 jurors were interviewed in a substantially limited way. For example, the very limited questioning by Juror Thorpe about whether he did any research or if anybody talked to him about research, and not confronting him with the actual allegation of his misconduct. And I would also say that only Juror Ferguson spoke or tried to speak about the WhatsApp chat. The other 2 jurors who were interviewed were never questioned about the WhatsApp chat. And so if this court is inclined to think that there's not a basis on this record for a new guilt phase, I would ask that the court remand for further juror interviews of all 12 of the jurors, and in a complete fashion addressing all of the allegations of juror misconduct.
But didn't defense counsel had the opportunity, was free to interview those jurors on his own, right?
Yes, and so
And in
that
fact, he
does get
filed the
into
notice and-
the second and really the third point on appeal. I do think it's important that we distinguish between these interviews. The interviews that the court conducted were by court order. The jurors were required to come. The 3 jurors were required to come. They were placed under oath, and the judge asked them questions. At the end of that hearing, the court said, I am not ordering any more jurors to come in. I'm not putting anybody else under oath. You all attorneys can talk to whoever you want, but I'm not ordering it to happen. So when we talk about what the sort of voluntary, discretionary juror interviews that the defense filed a notice of and was seeking to conduct, that's a very different type of interview than these court-ordered interviews.
Sure, but if the argument is that the trial court, that the error here is that the trial court failed to order or interview more jurors.
Yes, correct.
But the lawyer didn't do the work to come forward and say, here's why you need to interview these other jurors, because I've talked to them, and this is what they said, or alternatively, I've tried to talk to them and they're refusing to talk with me. So, Your Honor, please help me out on this.
Sure. I would suggest that the legal analysis here is to look at the motion that was filed by the defense. And the motion filed by the defense did talk about specific allegations made by juror Ferguson and specific things that were said in the group chat that would
Right,
support.
but nothing learned by counsel doing his own legwork to figure out if there's some issue. I understand that it would have been better, would have preferred to just have the judge order them to come in. But he was still open and still had the opportunity to do those interviews and then come back to establish or perfect the record as to why that trial judge erred by not ordering more interviews.
And I don't think that that is required based on the legal issues at play here. One are the court-ordered interviews, which he was asking for more of those. He was asking for all 12 jurors. The second are solely discretionary, voluntary interviews that the jurors were under no obligation to comply with. And even if they did agree to speak with defense counsel, they were under no obligation to tell the truth. So we're talking about, apples and oranges, essentially. Doing the voluntary interviews would not necessarily have given any more credence or credibility to the defense motion, which was fully pled, fully ruled on, and as was noted by the court, was preserved. To continue in point 2, the trial court interfered with the agreement proposed by the state and the defense to waive death in exchange.
Since you just spoke about preservation, do you concede that this point is not preserved?
With point 2?
Yeah, did you preserve this below?
Point 2, oh, no, I would agree that for everything except the Sixth Amendment argument, we are traveling under fundamental error.
Okay.
Yes. There's 3 constitutional problems with the court's conduct here. The first is that the court violated the separation of powers doctrine under the Florida Constitution. The second is that the court violated Mr. Avsnew's Sixth Amendment right to effective counsel, and that is preserved based on the arguments that were made below. And finally, the court violated Mr. Avsnew's right to be free of an arbitrary and capricious death sentence under the Eighth Amendment.
I'm a bit of a loss. In the middle of all this, the state offered a deal to your client.
I'm sorry, Justice Labarga. Now it's my turn. I can't hear you. Could you speak up?
Okay, you got me. Can you hear me now?
That's better.
The state offered a deal to your client, no more jury interviews in exchange for a life sentence. The trial court's only role at that point in time was to proceed to sentencing because your client was vehemently against waiving more jury interviews. So the trial court basically said, instructed the state, if you, and I'm quoting, if you want to waive the death penalty, go ahead and waive it. But the court refused to call off the penalty phase. which I think is your issue here, based on a deal which the defendant objected to. The court actually said, if you have a meeting on the minds, I'm happy to do what you want. He's willing to take the deal. You don't have a meeting on the minds. So the state then said it would not be waiving. Your client then stood up and basically said that he objected and informed the court that he wanted to proceed pro se from that point on because he didn't think his lawyers were doing what he wanted. So he wanted more jury interviews. All the court did is say, this didn't happen in front of the jury. He said, when you get a deal, let me know, I'll take it. Well, until then, we're proceeding to sentencing. What is wrong with that?
That was not within the court's purview to hold. And I say that because whether or not Mr. Absnew's lawyers engaged in further juror interviews was a discretionary function of the lawyers. It was not a decision that Mr. Absnew controlled. The law is clear that a defendant controls the end goals of the representation, but not the means on how they achieve the end goals.
Well, I agree that counsel stating to the judge, my client's against it, we want to proceed with it anyway. I don't know where that was coming from. But as far as the judge's involvement, all he was basically saying, okay, once you get a deal, let me know, I'll take it. Until then, we're proceeding the sentencing phase. I don't understand what the problem is.
Well, let's go back, talking about the separation of powers. The sole discretion on whether or not to seek a death sentence rests with the prosecutor. Part of that discretion is that the prosecutor can negotiate whatever terms it requires for waiving the death penalty, provided that those terms don't violate equal protection or some constitutional right. That's solely within the prosecutor's discretion. Here, the prosecutor bargained for the defense attorneys not to conduct the voluntary interviews or not to try to conduct the voluntary interviews. That decision rested with the defense attorneys to make. Mr. Absnew was not entitled to force his lawyers to engage in those discretionary interviews, nor was the court. Once the court had denied... Why wasn't
he entitled, though, to insist that a penalty phase proceeded? I mean, doesn't the question depend on what lens you look as, like, the overall deal through? So if his desire is to proceed with a penalty phase, it's not really an issue about whether or not to conduct these interviews. It's more about agreeing to a life sentence or, proceeding with the penalty phase.
Mr. Absnew and any defendant charged with capital murder is only entitled to a penalty phase if the state is seeking the death penalty. So once the state indicated that they were willing to waive the death penalty based on factors that would not implicate any of Mr. Absnew's rights, he was no longer entitled to a penalty phase.
Well, you're saying the court pressured the state into dropping the deal?
Correct.
Either you go to trial, proceed, or take the deal now. And you say that's the problem.
Can I just clarify? Is the court asking if the problem is that the court, for lack of a better way of putting it, forced the state to...
No, but pressure them and basically saying, I'm ready to go now, either take the deal or we go to trial, we continue with the penalty phase. And that in itself caused the lawyers to drop their proposal to plead guilty and whatever, accept the sentencing that's life and instead of the death penalty.
I mean, there was really nothing for the court to do once the state said that they were entering this agreement other than to proceed to imposing a life sentence.
So, I mean, I'm just trying, having been a trial lawyer for a long time, judge, I'm trying to figure this. The lawyer comes, we're about to start the penalty phase, so we're in the middle of the penalty phase. The lawyers advised me, in the absence of the jury, that we have a deal between the lawyers and the state. The problem is our client doesn't want the deal. And I say, well, I mean, let's proceed with a penalty phase and come see me when you do have a deal, and I'll take it. I don't understand what is wrong with that. How is that in any way affecting the separation of power?
So I would suggest that that's the appropriate way for the judge to respond when that deal requires the defendant's personal waiver of a right. For example, pleading guilty or waiving the right to appeal or something along those lines. Here, it's not just how the court proceeded, but it's also what the court said, specifically going into talking about whether defense counsel was being ineffective or would be found ineffective in a future post-conviction motion by agreeing to this strategic decision without his client's permission or agreement.
He said he will be back in 5 years from now in a Rule 3851 or 8.850. He prefaced what he said later with that. If the client didn't agree.
So when we're talking about the effect that that had on the prosecutor, causing the prosecutor to say, well, no, then let's just proceed to with the penalty phase, I think it's important to look at how the prosecutor conveyed that. The prosecutor specifically referred to the conversations the court was having about post-conviction and 3850 or 3851, and that was the reason the prosecutor was not just agreeing right there on the spot.
So that's essentially what Justice LaBarga said. You're saying he was bullied by the judge into it, pressured to do it. Okay.
Yes, absolutely.
So the exchange there were parts of it that were sort of convoluted and hard to understand, but at one point were they talking about on the defense side, or maybe only the defendant's side, that there was some concern about appellate rights in play? And so it was his, I mean, obviously if you just focus on giving up the penalty phase, it seems irrational, because if you're being offered a life sentence anyway, why would anybody do that? But I mean, was there some view that if they didn't pursue the additional interviews, that somehow he wouldn't be able to contest whether there needed to be a new guilt phase because of whatever the misconduct was? I mean, is that what he was thinking, as far as you can tell?
I think that is correct, but I also think that that is due, at least in part, because the trial judge initially told him that. So when the trial judge first started questioning Mr. Avsnu, he said, you're going to be giving up your appellate rights with this agreement.
Vis-a-vis the guilt phase redo because of the
correct.
Because
well,
of
he
the
said,
thing.
Giving up your appellate right, specifically with respect, in the context of this conversation, with respect to the juror interviews that had already been preserved.
And is that factually accurate, or would it have just been an appeal that just may not have been as strong as it would have been if there had been more interviews?
Well, let me back up. Are you asking me if this would have waived the?
I mean, was that part of whatever this agreement was? I mean, could he have still? So they would have had the same appellate issue on the guilt phase, but it just would have been based on the record as it stood then, as compared to a record that might have gotten better for him if there had been more interviews.
Correct. It's the second, and I think defense counsel eventually did clarify that for the judge somewhere further into the hearing. But at the very beginning, the judge told Mr. Avsnu that the agreement would involve him waiving his appellate rights, and that was part of Mr. Avsnu's calculation.
So would you agree then that meaningfully distinguishes this case from, say, Figueroa Sanabria, where the decision by the client is made under a fundamental misimpression of the law because of advice, quote unquote, given by the judge? Here, there was a corrective, right?
It was corrected as to the appellate rights. My argument about the court's coercion of Mr. Avsnu into waiving his right to counsel is still based in an analogy with Figueroa Sanabria, but more to the effect that throughout this entire hearing, the court is continuously talking about how Mr. Asnew's defense counsel is being ineffective, or at a minimum suggesting they were being ineffective for agreeing to this without Mr. Asnew's consent. And there's multiple times where the court made statements where he was overtly conveying that he thought that this was ineffective assistance of counsel, specifically talking about how Mr. Asnew would have a valid claim if he raised this in a 3850. The court walked through what a 3851 hearing would look like, what sort of evidence would be presented, talking in pretty pejorative terms about how that evidence would reflect on defense counsel, specifically naming defense counsel, talking about, that the evidence would show this was a horrible decision by defense counsel.
Okay, I'm sorry to interrupt you, but you can have 2 minutes for rebuttal.
Okay. With that, I would ask that this court remand for a new guilt proceeding or other relief requested in the briefing.
Thank you.
May it please the court, Lisa Marie Lerner with the Attorney General's Office for the state. Going to issue 1 about the jury misconduct. All of the evidence showed that the misconduct started after the guilt phase. The WhatsApp group started the actual misconduct in July, when the jurors started commenting about watching a video, and they told each other, you all should watch the video, and other jurors said that, wow, based on the facts of this crime, I can't imagine what the defense is going to present at the penalty phase. That's when the misconduct started, and it continued from there.
This isn't our case, but would you concede that if instead the statements on the WhatsApp chat had been something like, gee, I can't believe we got away with all the secret conversations we were having during the guilt phase, even though that chat had started afterwards, it could, in theory, have cast doubt on the guilt phase, right?
Absolutely. Okay. And in that case, the state would agree that perhaps the court should interview jurors about the guilt phase. Okay. But that's not the situation here. And in fact, the state agreed to a new penalty phase based on the misconduct that was brought out. The state did not resist that at all. Juror Thorpe and Juror Calderon both said that there was no misconduct at all during the guilt phase. Juror Thorpe admitted that he acted improperly before and during the penalty phase because he watched a video. He also testified that someone else in the penalty phase brought up a letter that had been redacted during the guilt phase, but one juror found an unredacted letter and told all the other jurors about it. That was from Juror Thorpe, who was being forthright when answering. Juror Calderon did not admit doing anything improper and said that he saw no one else doing anything improper. Juror Ferguson was a little scattered, to be polite about it. However, even she said that the first part of the trial, I think most of us didn't research anything because most people were unsure about a decision. So we sat down and talked about everything, and then we made our decision with the evidence that we looked at and everything. That was her comment about the guilt phase. So based on that, on the court's questioning of those 3 jurors, there was no basis to interview other jurors about the guilt phase. There was also no basis to interview the other jurors, because the state conceded a new penalty phase was needed. So the court correctly set a new penalty phase but denied a new guilt phase based on this evidence. And there was no basis to interview any more jurors. And the court did not abuse its discretion, and we asked this court to affirm the trial court's decision. In issue number 2, there is no separation of powers problem here. The court specifically told the state, if you want to waive the death sentence, go ahead and do it. That's your power. But if you're conditioning it on Mr. Afsanu giving something up, that's different. So if you're really set on waiving the death penalty, do it. And the state attorney said no, he was not going to do that. He would only waive the death penalty if the defense did not go forward with juror interviews. Also, involved
Can I ask you a question about that? The defendant was indicted by a grand jury for capital murder, and the case proceeded under the statutes that obviously makes murder a capital offense under 775-082, which then in turn states that the penalty, if he's found guilty, is death if the procedures of 921-141 are followed. So he's already convicted of capital murder, moving into the penalty phase, and they've already presumably filed a notice about at least one aggravating factor that the prosecutor will show during the penalty phase. This process is already going on. How does the state attorney at that point even have the discretion to pull that back once there's a conviction and the law is already, basically self-executing, requiring that there be a penalty phase, because the penalty for capital murder is death if this process is followed?
Yes, or in the alternative, life without the possibility of parole. And if the state refuses to proceed, it's the state.
Well, it actually says it's death if the process is followed, and otherwise, and then part of that process is if it's not shown, if it's not, the aggravating factor is not proven beyond a reasonable doubt, there's not a recommendation, then the penalty is life. But the penalty for capital murder is death if 921-141 is followed.
Yes, but it is the state's prerogative not to seek the death penalty, not to proceed to the penalty phase.
And where
trial.
does that come from?
Prosecution, the power to prosecute.
But is it prosecution at that point? The prosecution he's been convicted of capital murder. So, now you're entering the penalty phase, and it's more of a sentencing aspect of it. And where does prosecutorial discretion come in that front?
I take your point.
Yeah, but related to that, isn't the state attorney's office, the Office of State Attorney is created under Article 5, which suggests that at least technically under the Constitution it's part of the judicial branch. So if the argument from the other side is that this is somehow a violation of separation of powers, I'm assuming you would agree that it's not, because in part the state attorney is not part of another branch, which is what Section 2, Article 2, Section 3 requires.
Yes,
for it to apply. So if you have a judicial officer and there's this conversation between the judge and the state attorney on any of this, how would that be a separation of powers issue? I'm assuming you would agree, but I'm just maybe rhetorically.
We did argue that it was not a separation of powers argument. I did not raise that point, however.
Can I ask you about this issue with the waiving the death penalty and what the trial court did? How much does the merits of this turn on whether the trial court was right about the necessity of the defendant agreeing to it, in the sense that if he was wrong and if this was a strategic decision by, that counsel could have undertaken, then doesn't it make it hard to sort of, ignore the fact that he basically prevented this thing from going forward through all of his comments?
I disagree with the premise of your question, because the defense had about a year to conduct these discretionary interviews. This blends issues 2 and 3. During that year, they did not attempt to interview any of these jurors. And so they came up at the last minute with this bargain, but they did not discuss it with Mr. Afsanu. When they did discuss it with the defendant, he objected to it. and he told his attorneys that he was not going to go along with it. He wanted his penalty phase trial. And it is his decision whether or not to have a trial.
But I mean, you agree that really the only, and maybe it doesn't matter if it's completely irrational, but the only way to kind of make it rational to insist on the penalty phase is if you think that you're losing something vis-a-vis the guilt phase juror misconduct by taking that deal, right?
Well, I disagree with that too, because in the hearing on September 26th, the first person who mentions appellate rights is the defendant. So apparently his attorneys must have talked to him about this privately and discussed appellate rights.
Well, I mean, I don't know if we can, I mean, maybe. I mean, this guy's pretty smart, right? I mean,
right. The defendant said, I am absolutely not conceding any of these appellate rights under any circumstances ever. That was his first statement, and it was within 3 pages of the beginning of the hearing.
So what appellate rights were in play?
About the juror misconduct and juror interviews. He wanted, as Justice Tannenbaum said earlier, he wanted to perfect that appellate issue on the guilt phase and to attack the guilt phase on the basis of jury misconduct.
Well, he wanted to, I'm sorry for interrupting you, but he wanted to potentially strengthen it, not perfect it, right? I mean, that's the issue. Like, do you agree that he still could have appealed if the deal had gone forward, there still could have been an appeal on the juror misconduct issue as to the guilt phase based on the record as it then stood?
It is shockingly weak to attack the guilt phase on the basis of the record as it exists. In order to actually have a meaningful appeal to attack the guilt phase, you'd have to at least get other juror interviews.
Okay, and is that, and you might be right about that, but is that the type of thing that would go in the bucket of lawyer-controlled sort of strategy?
No.
No? Why?
Appellate rights, whether or not you're
Well, you have an appellate right. I mean, it's a question of how strong is the appeal going to be on that versus getting a life sentence guaranteed.
It is essentially the same. What they were doing was essentially asking the defendant to give up a meaningful appeal on these issues. So given his stance on that and his stance on being adamant about having another penalty phase trial, the court said, well, I'm not going to, ask him to give anything up. State, if you want to waive the death penalty phase trial, that's up to you. And the state said no. And so the court was left with a situation where the defense attorney is saying it's strategic, the defendant is saying, I want my trial, I'm not giving anything up, and the state saying, well, we're going to have a trial. So in that situation, the only thing the trial court could do was proceed to trial.
If you assume that the defendant's opinion on that matters. And I don't mean that to sound cold, but there are, in this area, there are certain things where the lawyers get to make the call, and there are certain things where the defendant has to buy in, or else there's a problem. I mean, is that premise right?
Even assuming that the defendant did not have a say in this process, even assuming that, you still had the state saying we're going to trial. And so the court could not, and the court did not pressure the state. The court
basically intervened and put himself in the middle of the whole thing and said, I'm not going to, basically the court took it upon itself to kind of try to vindicate sort of the right of Avzanu to decide this, to decide this issue as opposed to deferring to the counsel. And it seems like there are some things where it's appropriate to defer to the counsel.
Well, what the court was faced with was defense counsel came in and said, we have a deal, but there's a little problem. The defendant won't agree to it. And then at that point, the defendant himself pipes up and says, absolutely not under any circumstances.
But going back to the argument, I mean, it seems like the state withdrew the offer after the judge made the comment, fish or cut bait.
Well, the state's comment was, given everything that I've heard during this hearing and what the defendant said and what the court said, I'm not willing to go forward with this bargain.
Well,
But it also...
The lawyers basically took the position, look, the best we can do with this defendant or our client is a life sentence. The worst that can happen to him is a death penalty. So we're taking that position. And it seems like logically, it may have been a strategic decision, but the whole thing came to an end once the judge interjected himself and said, you know, either you're going to take this deal or we're going to proceed to the final hearing.
Well, and the court did that only after the defendant very adamantly on multiple occasions said no. And so you have a situation where the defendant is saying, I want to go to trial. And the court actually did a colloquy with the defendant and said, look, they're offering you life. You're not going to have a problem, you know, with this. It's all going to be settled. This is why you have a penalty phase trial, is to try and get life, and they're offering it to you. And the defendant said, no, I want a trial.
So if we rule in your favor, are we making new law in this kind of division of authority between counsel and clients in this area?
No, I think it's a continuation of this court's precedents.
Do you think perhaps another way to look at it is that there were strategic decisions that could have been made by both sides? The state, and nothing prevented that. The state could have waived, and nothing prevented them from doing that, correct? The defense could have made, the counsel could have made a strategic decision to not interview jurors, and no matter what their client said, correct?
Yes.
Both of those things could have happened. But when they attempted to negotiate them to an agreement where one person had to do something in order for the other, then it became an issue in front of the court that involved the defendant's process, the defendant weighing in on that. Because now it's an agreement, it's a negotiated situation, not an independent decision that either of them are making. Is that perhaps one way to distinguish it?
Yes.
Okay.
Thank you.
Counsel, you would agree, though, I mean, not though, you would agree that this is not like a plea agreement, right? I mean, they're not, the defendant is not being asked to plea to anything. He's already pleaded not guilty and has been convicted.
That's true.
So how would an agreement like this work anyway? I'm just not understanding how, what the appellant is even asking for in terms of enforcement. Like, what would be the consequences? You can't move, there's nothing to withdraw, and in that sense, it doesn't really matter what the judge said or didn't say in this, because the counsel could have just told the state attorney offline, look, I'm not going to ask for, I'm not going to do any more jury interviews, and the state attorney will agree, look, we'll go to the penalty phase, but I'm not going to present any evidence on any of the aggravating factors. We'll just rest, and and then we'll leave it at that. Right? That could have also happened. So this idea of waiving the penalty phase and seeking the judge's permission doesn't really matter what the judge said.
Yes,
right?
That's true.
Well, but I mean, that's in the alternate universe where the prosecutor isn't allowed to just waive the death penalty at that point. I mean, obviously, they're trying to work this thing out. The lawyers had this agreement. The counsel had made a judgment call that this, the potential claim on the guilt phase misconduct was never going to be strong enough to be, worth giving up the life sentence for. And basically, the judge, on the theory that it was the defendant's authority to kind of stop that from happening, he had basically intervened and stopped it.
No, he intervened and told the state, look, it's your decision. I'm not going to sit here and say that he has to give up anything that he doesn't want to.
Right, but he stopped the deal. I mean, you're basically offering the state a different situation than what they had worked out between themselves.
I think the defendant stopped the deal because The defense attorney and the state attorney didn't go into the courtroom and say, we're not going to have a penalty phase trial and I'm not going to interview any jurors, so please proceed to sentencing. They started with, we have a deal, but the defendant won't agree to it, but he doesn't have to agree to it. So they were trying to do an end run around both the penalty phase trial and the defendant's wishes. And it was such a highly unusual situation that the court questioned it.
Well, wouldn't you? I mean, I'm not like Labarga. I haven't been doing this for 25 years or whatever, but this is bizarre. I've never seen this. I've never seen a colloquy like this where this guy can basically get a life sentence guaranteed after 24 jurors have said that he should get the death penalty. I mean, and you basically think that this juror misconduct thing is frivolous, essentially. So he's not giving up anything. Yes. He's not right. So he's not giving up anything. I mean,
but he believes that it wasn't frivolous, and it's his right to. It's his right to have that explored. Granted, the defense attorney can make a strategic decision or an informed decision. Look, it doesn't really seem like there's anything there. I'm not going to pursue it. But the defendant wanted it pursued. And that leads us into issue 3.
But that's what I was asking about before. So even if the defendant said, yeah, I don't want that, the defense attorney could have just still told the prosecutor, look, but I'm not doing any interviews. And you can, in return, the understanding is that you're not going to present any evidence at the penalty phase, or or waive it, or tell the judge, like the judge invited us, like, look, if you want to waive the penalty phase, go right ahead. And the prosecutor could have done that with the understanding with the defense counsel that they're not going to do any interviews, or he's not going to do any interviews in return. It wasn't that essentially what the judge was telling them is, look, I don't have anything to do with this. Why are you coming to me to bless some sort of agreement that you have? Because it's not my business.
That's exactly what happened. And as I said, the state reneged on the deal, and so they had a penalty phase trial. But going quickly into issue 3 about the court's comments making the defendant go into represent himself, I don't think that's correct. First of all, the defendant represented himself at the first penalty phase trial, and repeatedly during the course of this retrial, he wanted to go pro se multiple times but backed down. And during this year between the penalty phase, which was thrown out, and this one, the issue of the juror interviews was percolating. And the defendant kept pressuring his counsel to interview them. They weren't interviewing him. So after the guilty verdicts, the defendant wrote a very detailed letter to the court in June saying, I'm going to represent myself at penalty phase because they're not doing X, Y, and Z, including interviewing the jurors. And the defense counsel went to the jail and talked to him for a long time, and then they came back to court in early July, and Mr. Afsanu withdrew his pro se request. That is the background. So now we're at this hearing right before the new penalty phase where counsel comes forward and says, we have this deal, we're not going to do the jurors, and Afsanu had had it by that point. That's why he wanted to go pro se, not because of anything the court said. And the record fully supports that, and the court did not abuse its discretion in allowing the defendant to go pro se. Also, this issue is also not preserved. If the court doesn't have any further questions, we ask it to affirm.
Thank you.
So, Chief Justice Muniz, to quickly address Your Honor's question about whether the defendant was waiving his appellate rights or whether he thought he was waiving his appellate rights. I want to make sure that it's clear the prosecutor below was not requiring him to waive his appellate rights on the juror issue. And that's at 2267 of the record and 2291. And I would also say that the state in their answer brief conceded that the jury interview motion was preserved, and that's at page 35 of their answer brief.
What if he took, if the judge took the deal, accepted the deal, then there would have been no need for jury interview. So it didn't have to really be a condition.
Well, if the judge had allowed this to go forward, it would have taken death off the table. It would not have negated the issues with the guilt phase misconduct. So it could potentially have still been an issue for appeal. It's just the appeal would have gone to the 4th DCA instead of to this court.
Why did the judge have to allow the deal to go forward at all? Like, why does the judge have to be involved?
Well, the judge didn't. I think, we've talked a little bit about how even if the state had the ability to do this on its own and the defense had the ability not to do the interviews on their own, the fact that they did it together and they did it in a hearing in front of the court is what creates the problem. But I don't think that that takes away from the fact that, number one, these are still two very distinct discretionary functions, and whether they do it in tandem as a negotiation or whether they did it separately on their own, it doesn't change the fact that it's discretionary either with the prosecutor or with defense counsel. I think it's actually commendable.
The judge didn't have the authority and said as much. I'm
sorry,
not
could you
involved.
repeat that?
If you want to waive it, then waive it. But this has nothing to do with me.
So I think it's commendable that they actually did give voice to this in a hearing, because it did allow ASNU to put his objection on the record. They could have just done this as a backroom deal, but that would have sort of been duplicitous, I think. So the fact that they did raise it in this hearing is actually commendable, but I don't think it takes away from the legal analysis of this was a discretionary function of the two separate counsels.
Okay, you can have 30 seconds to wrap up.
Thank you, Your Honor. I would ask this court to reverse for a new guilt phase or whatever other relief it sees fit based on the request in the brief. Thank you.
Thank you. We're adjourned for today.